Some of them go ahead to become real penalties that you pay. Some of them don't.
Are you saying that we should follow Boyles and Moore then along the continuum of whatever these violations had been that were cited against Smithfield Foods, and look at Boyles and Moore as being dispositive?
Well, Boyles and Moore are not dispositive because they're not the same situation. Just because in Boyles and Moore you had ABC equals penalty doesn't mean if you have another case, A, B, and D, that it's also not a penalty. It would not follow. It may help if I took just 1 minute to concisely summarize our position. It's one long paragraph, but it's one paragraph. Because this case is unlike others, but it takes from many of the principles of Caldwell, Boyles, Moore, Shore v. Edmiston. This is not a settlement because the Attorney General has identified no authority for him to execute and no power to enforce it other than an exception to the gift ban. He called it a settlement agreement at the announcement of the first announcement of grant funds. In deciding functionally what the $50 million is for, labels, collection methods, exculpatory recitals are disregarded in your previous cases. The question is whether the payments are used for measurable remedial measures or to deter future non-compliance with the law. Claims that a payment is voluntary may be euphemistic at best. And the fact that payments go to a third party does not change the nature of the payments. The question is, would those payments, $50 million, have been made if not for the actual violations committed? As a consequence, the remaining funds should go to the public schools, not to grantees selected by the Attorney General in his sole discretion. If Smithfield defaults, the remedy for the courts would be under subsection 6, as I said, where he could collect it as a debt, but then it would go to the Treasury, from which it would thence go to the civil penalty and forfeiture fund, where it should go to the public schools.
I'm trying to understand your argument that this agreement is designed to deter future violations and therefore it's a penalty. As I understand it, typically a penalty deters future violations because the violator doesn't want to have to pay another penalty. But under the terms of this agreement, future violations, whether they happen or don't happen, doesn't change what Smithfield is paying. And in fact, I understand the record that there were future violations found for which penalties were assessed. So how does this agreement deter future violations?
And Justice Earls, that of course was in the immediate era right after 2000. What I think you're referring to, that there were some other things assessed at that time. It was Smithfield, as they say, that chose to stretch this out over 25 years. Whether that was a cash flow issue, which I doubt, or whether it was because Smithfield wanted extra publicity, good publicity for 25 years. Sort of doubt that too, but it was Smithfield's desire to stretch it out over 25 years.
What about the fact that Diener was not a signatory, Diener as it was called then, is not a signatory on this document? Isn't it? The AG's office does not control Diener, correct?
Well, the AG does not control Diener, but the AG goes to court for Diener all the time, and I believe part of the Attorney General's office represents the Environmental Management Commission, which is the one that can do remittances.
Oh, but legally, they're legally distinct, right?
They're distinct legally, yes.
And isn't Diener the one, at the time, Diener charged with enforcing environmental laws?
That's correct. And this goes to the Attorney General's citation of the Tice case, Tice v. Department of Transportation, as its authority for, lots of things the Attorney General can do. And the Supreme Court, this court in Tice, made just the point that you made, and that is the Attorney General cannot settle a case for DOT without the Secretary of DOT approving it. So, is this
Let me
binding
back
on?
up to Justice Earl's question.
Yes.
The question was how, if the payments are going to be made regardless of what happens, how does it deter future violations? And your response was that Smithfield chose to spread it out over 25 years. What difference does it make whether it's paid all at once or over a period of time in terms of deterrence, if you have to make the payment
Yes,
regardless?
just as, I don't believe that Smithfield could back out of the agreement. But one of the positions of the Attorney General was that, taken today, I believe, if I remember his answer, was that if it was, it depended on your ruling in this case, that Smithfield could back out of it and not pay. Now, that's not our position, but maybe that's why Smithfield said the third possibility is let's spread this out over 25 years, because there's no real consideration for these gifts, and if the Attorney General does not ensure that we are in compliance 100% of the time, maybe we can save a little money. I'm speculating. But
To
You
go
can
back
come
to
to-
an
I'm
answer that you gave to Justice Davis, if Tice holds that you can't settle a DOT proceeding without the consent of the Secretary of the Department of Transportation, does the Attorney General have the right to settle an environmental proceeding without the consent of the Secretary of the Department of Environmental Quality?
well, our contention is the Attorney General had no right to sign this agreement.
Well, I mean, I
Any case,
understand that,
with
but
or without.
assuming that we've got your argument, your principal argument is this is essentially a substitute for a penalty. I want to go back
Right,
over our
right.
prior discussion.
Right.
But in the event that we've got, in essence, a substitute for a penalty, in order for it to be a valid substitute for a penalty, would the Secretary of the Department of Environmental Quality have to sign off on it?
Well, I believe that is true. Yes, and that's another reason
And
why
they're not a party to the agreement. They obviously knew about it, but they're not a party to it.
they helped negotiate it, but are not party to it.
Okay.
That's another reason. Since I have
But
30
on that same logic, would Diener be bound by this agreement going forward?
I hadn't thought about that, but I think the answer is no. I think I can get one thing in 15 seconds. The newspaper article added to the state's reply brief, State v. Williams, terrible precedent. I hope you'll disavow it. Putting facts in the record by tweet and newspaper is a dangerous precedent. Thank you very much.
Thank you, Mr. Stam. Mr. Doggett.
I only have a minute, so I'll try to make this very quick. If you listen closely to what my colleague said, I think he effectively said that he conceded that this is not a settlement. Instead, he argued that somehow this agreement falls under Article 9, Section 7, because the Attorney General agreed to work with Smithfield to bring it into better compliance with the law. That's simply not a settlement. And actually, again, with the evidence that we submitted at summary judgment, we showed that after the agreement was entered into, DENR, today DEQ, continued to issue assessments of civil penalties, notices of violation, and then to resolve this on a one-off basis. So the notion that the settlement, or that the agreement is somehow a settlement, is totally contradicted by the record. And as a result, we would ask you that you please reinstate the summary judgment that was granted by the Superior Court and reverse the Court of Appeals. Thank you very much.
Thank you, Mr. Doggett. Thank you to all counsel. Thank you so much for being here today. We know there are also students here as well, and we're delighted to see you all here. Madam Clerk, would you recess this for 30 minutes? All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 30 minutes. God save the state and its honorable court. All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court. Good morning again. We are glad to be here for the second argument here in historic Randolph County. This has been an amazing time, and we're just so grateful for everybody who has been so gracious in helping to make this happen, to host the Supreme Court of North Carolina in this 200th anniversary year for the court. I am Sherry Beasley, the Chief Justice of the Supreme Court of North Carolina. To my right is Senior Associate Justice Paul Newby. To my left is Justice Robin Hudson. To Justice Newby's right is Justice Sam J. Irvin IV. To Justice Hudson's left is Justice Michael Morgan. To Justice Irvin's right is Justice Anita Earls. Justice Mark Davis is not with us today. He is observing Rosh Hashanah, but he is also recused on the matters before the court today, and so he will not be participating in this court's decisions on these two cases. The court calls City of Charlotte versus Universal Financial. Mr. Meeker.
Chief Justice Beasley, member of the court, and may it please the court. My name is Charles Meeker. I'm with the law firm of Parker Toad, Absalom, Raleigh. With my colleague Steve Perry, we are representing the City of Charlotte. First, let me thank the court for taking this case on discretionary review. I know the docket is busy, and we very much appreciate having a notice of part of our review and taking a full look at this case. The first issue is when a motion to amend the city's pleadings to reduce the amount of just compensation is pending. Does the trial court have the power to decide whether the landowner's dismissal is effective? That's the first question. The facts in this case start with the filing of the complaint in April 2013. The amount of just compensation and a deposit was estimated at $570,000 and included both the land taken as well as off-site impacts for a nearby bridge. When this came to be discussed in mediation in the fall of 2014, the city then filed motions to determine issues other than damages, and also a motion for partial summary judgment to have the court rule that the off-site impacts were not compensable in this condemnation action. While the trial court did not agree, the Court of Appeals, within Judge Davis, now Justice Davis, ruled for two reasons that the off-site impacts were not compensable. So when the matter came back to the trial court after discretionary review was denied, the city moved to amend its estimate of just compensation from $570,000 to $174,000 to take out the effect of those off-site impacts. The city did not move to change the deposit. So the question here is, okay, we now have this notice of dismissal. Let me put that in. Units of properties filed notice of dismissal a week after the motion to amend was filed. So then the trial court's faced with this motion to amend to reduce the amount of just compensation requested by the city, and then also this dismissal by the landowner. With the Chapter 136 eminent domain statute, the rules of civil procedure do not have any process for a defendant dismissing an action. There is a process, of course, for an amendment of the pleadings of Rule 15, and also under Section 103D of the condemnation statute, which allows amendments at any time.
The majority's position in the Court of Appeals, as well as your opponent's position, that because of this unique statutory construction that undergirds eminent domain, that as a result, a defendant in a condemnation action is really like a plaintiff in terms of being the one that would initiate the dispute, because otherwise there would be no dispute, as a plaintiff typically is the initiator of a controversy such as the one here that would involve damages.
Well, there are some similarities to a defendant's position in a condemnation action to a plaintiff's position in a normal civil action, but there's one really, really big difference that applies here. That is, under Rule 41, when a plaintiff takes a dismissal, the plaintiff walks out of the court with nothing other than the right to file again within a year. In this case, if the dismissal by the defendant is effective, then the defendant will walk out of the court with or will keep a deposit of $570,000, of which $396,000 is in dispute as being an excessive amount, and thus obtain a windfall of $396,000, being allowed to file that dismissal if it's effective. And that's the reason that the statute of 114, section 114 of chapter 136, gives the trial court the power to make decisions on issues of procedure when there is nothing in the rules of civil procedure and there's nothing in the condemnation statute either.
That determination that is submitted.
Well, that of course is the city's contention. The initial deposit included these offset impacts, which the Court of Appeals found were not permissible. So now the city has re-estimated the amount of just compensation just for the land taken, not for the offsite impacts. And the city's estimated that at $174,000.
The windfall is occasioned by the fact that the bridge is not determined now to be one that would impair the site opportunities, and so therefore, since it does not impair the landscape review, the value.
Yes, well, the amount of compensation, I think the court decided that there was effect of the bill, it's not something that's compensable in this case. It's not compensable unless the city's estimate is $4,000 instead of the one that included the offset impacts. Now, of course,
all on the responsibility of the community authority. Certainly in the course of discovery and leading up to trial, the condemning authority could say, well, we misvalue any particular aspect, and now we deposit risk, but maybe we shouldn't. Why is it the responsibility of the condemning authority to make not just judgments as to the value, but also what is involved in the taking, and you have to live with whatever determination.
well, the statute does not require that there be no change. The section allows amendments, and that's exactly what this kind of thing is for. In case there's been a misestimation of just compensation, it's not the right party, the party's not described right. 103D allows amendments, and that's what it is for. Certainly be more desirable for the initial amount of just compensation to be estimated correctly. However, errors do occur, and that's what happened here. Of course, it was brought to the attention of the other side of the court very quickly. Okay, well, let me address that. The city has made no request to change the estimate of just compensation. So the amount of just compensation is ultimately determined. In excess of that, some would be refunded. If the compensation is more than that, then of course the city would owe more. But there's been no request here by the city to change the deposit. And we think the Court of Appeals, in looking at that statute, was off the mark. What we're talking about here is the estimate of just compensation. The deposit is something that's held during the course of the proceedings.
By the fact that the bridge is not
Determined by the condemning authority.
What's going on? I'm Kendrick Lamar, and I.
At the end of the trial, though, the court determines, the jury, someone determines that, hey, what amount is due is $200,000. The person who's making the decision, they have the right to go and, okay, yeah, we want that full amount.
No.
What's going
Under section 121 of chapter 36, there's an express provision that provides if the amount of just compensation is determined to be less than the amount of refunded, then that amount must be refunded. Under section 121, once you dispute the amount of just compensation, you put that issue in play. If you don't dispute it, you can keep the deposit and go. Once you dispute the amount of just compensation, once you give your answer and dispute the amount of just compensation, that issue is in play. And although often don't dispute value is more than what the deposit is, in the cases where it's less, section 121 makes very clear that excess amount must be paid back. Yes, right.
Continue to dispute that.
Whether it's effective, that's correct. And our intention is that the trial court under the section 114 is given the power by the General Assembly to make procedural rulings where there is no procedure set out either in chapter 136 or the North Carolina Rules of Procedure. And here the trial court did that. It looked at it and said, we've got these competing motions. The Here, the first estimate of just compensation appears to be excessive. It included these off-site impacts. And thus, I'm going to allow the motion to amend. I'm not going to allow a windfall to the defendant. Indeed, the purpose of Chapter 136 is to achieve just compensation. It's not to have some procedural impact, that gets to the wrong result. The trial judge is directed by Section 114 to try to achieve the purposes of Chapter 136, which is just compensation.
What is it about Rule 41A that doesn't, or A1, that's inadequate to address a situation where it says that the action or any claim therein may be dismissed by the plaintiff without order of court?
Right. Well, the plaintiff here is the city of Charlotte, and the defendant is the landowner. So Rule 40.
Morgan asked, it's treated more like the plaintiff.
There are similarities there, but again, this Rule 41 applies to plaintiffs. There's no reference to defendants. Defendants dismissing plaintiffs. And the difference here is, of course, I think I mentioned Rule 41. When a plaintiff dismisses, the plaintiff doesn't get anything. And here, if a defendant is allowed to dismiss, if it's somehow giving Rule 41 rights, he walks out of the court with a plaintiff.
So you're asking us to hold that Rule 41 does not apply to the landowner in a condemnation proceeding?
Yes.
Just flat out?
Yes, we are.
Okay.
There's been no motion to amend at all. Are you saying a defendant in these circumstances can never voluntarily dismiss?
You can admit the amount of defendant's dismissation is right, and that ends the action. Or you can not answer, that also ends the action. If, after you've answered, disputing that issue, you now want to end the case, you would then move the court to dismiss the answer, saying that you now think the amount of just compensation is correct. You would then, the condemning authority presumably wouldn't object unless there's an unusual situation like this case. And that's another point I want to make. This case is very unusual. I don't recall another one where a condemning authority has found out that its initial estimate was, this far off. So this is not as though this is going to affect a lot of cases as far as I know. But I think the answer is there is no right of the defendant in an eminent domain case to dismiss. So you have to go under Section 114, where the trial court would then, presumably would accept the motion in that case. There's no dispute at this point about the amount of just compensation.
Isn't that essentially what happened in the Coombs case? I mean, whether you characterize the defendant showed up in court and didn't put on evidence, or the defendant voluntarily dismissed, the ultimate outcome of that case was that the defendant dismissed their attempt to get more compensation and kept.
Well, there's a lot more to the Combs case. It was been called for trial. The landowner's attorney was saying that they didn't want to challenge the amount. Apparently the individual defendant did want to challenge the amount. There was no request to continue. And then ultimately the court said, well, that appears as though the defendant had abandoned the claim for more compensation. There, the situation was exactly the opposite here. That is, the landowner was trying to say, well, I didn't really dismiss or abandon my claim. I'm entitled to more compensation than what the state said. And here, of course, it's just the opposite. So I think the Combs case, one, is really rather different when you look at all the facts of it. And then secondly, of course, it's not authority that binds this court. I think this court needs to rule what the right answer is here in terms of whether Rule 41 applies to defendants, which we think it doesn't, and whether the trial court has the power under Section 114 to make procedural rulings. And on that, we think the Court of Appeals just used the wrong standard of review. That is, it went ahead and reviewed it, so it did its own review as to what it thought was fair, and also misunderstood that a motion to reduce the deposit was not an issue. It was a motion to amend the amount of just compensation. And here, certainly, the trial court's ruling, was a reasoned decision. It wasn't. I think that. Which is arriving at just compensation, which is the policy of the state. And the landowner is entitled to just compensation. The landowner is not entitled to some windfall where it gets 2 or 3 times the amount of what this compensation is. So in that first issue, we believe that the trial court is entitled to this compensation. So in that first issue,
the essence is that
trial court is entitled to this compensation.
a defendant in a condemnation action cannot voluntarily dismiss its claim and therefore put itself in the position that existed in the Combs case unless it is willing to accept the amount that the condemnor contends to be the amount of just compensation at the time of the dismissal? Is that your position?
That would be correct. That's the time they answered the amended complaint, which the judge allowed. They could then say, yes, we agree with that amount of compensation, $174,000, and that would end the case.
So in the event that the motion had been allowed, the motion to amend had been allowed, in your view, the defendant could take a dismissal at that point
They could
accept, in this instance, the $70,000?
Yes, they could accept 174 under the statute on the answer.
I mean, I think your colleague's argument is that puts us at, I mean, that the whole purpose of this is the process, and that this allows entities that are condemning property to create a moving target, and that's trying to I think that's one of the I mean, let's not just assume it's an improper purpose. Let's just assume there's a series of errors.
Well, I mean, the trial court would decide whether to allow that motion to amend. It's in the trial court's power to decide whether to allow that happen, whether that furthers justice, and whether that's a fair
So if the trial court had denied your amendment motion in this case, you don't dispute that the landowner at that point would have had the right to file a voluntary dismissal and take $500,000 and some odd thousand dollars in return to the initial deposit?
I'm not sure they would be filing a motion to dismiss the trial court denied the city's motion to amend. Presumably, the court would then grant a motion to terminate the case.
Or voluntarily dismiss, not a motion to dismiss. Sorry about that.
So your position is that there needs to be a stipulation of dismissal at this point?
Well, a stipulation of dismissal or the court's approval. Because there is no provision for a defendant just to dismiss in any, under Chapter 136 or in the Rules of Civil Procedure.
How does your view of Chapter 136 and the usage of Rule 41A fit this construct of a condemnation action, which is that when the plaintiff, such as your client, decides that it wants to condemn land for a public purpose, that the title automatically goes to that municipality or that governmental entity?
I think that part is really sort of separate from the amount of just compensation. If the title is vested at the time the suit is filed, so that part of the case is over. And what's left to decide is the amount of just compensation. And if the landowner agrees with the estimate of the condemning authority, the case is over. If they don't agree, if they dispute that and put it in play through their answer, then that's yet to be determined by the court. And that's where the court's power.
What I'm looking at relative to Rule 41A's usage is if you say that it's only available to a plaintiff such as, again, your client, as soon as title vests, then there would be no need to voluntarily dismiss by the plaintiff because the plaintiff's already gotten what it wants, which is the land and title to it. So really 41A is not available to any party, I hear you claiming, in a condemnation action.
Right. Well, once you have taken the title, of course, then the condemning authority cannot undo it by returning the property at that point. So I agree, 41A does not apply to either party in a condemnation action. That's correct.
So that's why Chapter 136 governs all of this?
It governs this, and that's why it gives the authority to the trial court to make reasonable rulings to carry out the purposes of Chapter 136. And again, that's Section 114 of Chapter 136. The second issue, and we've covered this pretty much already, is whether the property owner can keep an incorrectly large deposit when the motion is pending. And of course, we said that it should not. I think part of this is the Carly case, where there's a request for an affirmative relief pending by one of the parties that's in the case. And here, the city's motion to amend was in effect a request for affirmative relief, just compensation to be determined at $174,000 and not be determined to be $570,000. So for that second reason, we feel that the trial judge was correct in allowing the motion and not letting the dismissal be effective, and the court feels was not correct. Just briefly on a couple of rebuttal points, the defendant's brief refers to the vested deposit. I am not aware of any vesting of deposit. There is the vested right to just compensation, but the deposit itself is not vested. Indeed, under Section 121, part of it can be returned if just compensation is found to be less. We talked about the Court of Appeals' confusion on the issue of what the motion to amend was. It was motion to amend the just compensation amount, not to change the deposit during the trial. And thus,
I think your colleague argues that that's a distinction without a difference. In essence, if I'm reading the brief correctly, and you'll have a chance to correct me if I'm misreading it, she seems to be saying that you can't really separate the two, that if you amend the estimate of just compensation, you've effectively amended the deposit amount as well, even though you haven't, and I gather her theory is we had an absolute, at the time that the original estimate was 500 and some odd thousand, we had a right to go get that, and that by amending your position, you are essentially moving from a position in which you contest our right to have that entire amount to contesting, you don't contest the amount, the ability to keep all of that amount, you're to a position in which you are contesting her ability, in this case, to keep over half of it.
well,
And she thinks, in her view, that's essentially the same thing.
well, I respectfully disagree with that argument. That deposit and the amount of just compensation are two different things. Deposit is an interim step that the landowner is entitled to hold the money pending the determination of just compensation. So it's something that occurs prior to settlement or prior to trial, and it's not something that the landowner is entitled to. It's something they hold pending the final determination. Just compensation, on the other hand, is that final determination. So here, when the motion to amend was granted, it didn't affect the deposit. The landowner is entitled to keep that full deposit until just compensation is determined, and then it would have to either get paid more or refund some, depending on what that amount is. But there was a big difference in the function of a deposit pending the determination of just compensation versus the concept of what just compensation is. So I respectfully don't agree they're the same. Okay, and the final point was on the question about multiple motions to amend. Of course, if someone did that, the trial court would consider each, and presumably if they weren't, if they were for an improper purpose or harassment, or there were too many of them, the trial court would deny them. So that's something the trial court is close to the action and can make fair rulings.
Tell me the impact of the amendment, because it would seem to me that even without the amendment, the condemning authority could put on evidence that we made a deposit, but in actuality, the value is much less than what we deposited. And ultimately, if the court rules in favor of the condemning authority, it doesn't matter what the valuation that would have been set out in the complaint. Is that accurate?
Yes, you're exactly right. This is something the city didn't have to do, but it I know it from the notes, the really simple then what was initially estimate. As you say, trial was a fair estimate, and then we thought we could have estimate. So this is really additional words to the
So, could let's see, we'll take the
when it filed its answer under section 107.
the next day,
Next day, it filed their that is the initial complaint of 2014. Yes, they could have filed the answer the next day. Taking it to
no, but once they say we will this together, here, is there a point in
the section 107 procedure was passed once they filed the answer to dispute the amount of just compensation. At that point, they've got to trial budget.
Described 3 weeks down the road, 6 months down the road, there was no motion to amend the defendant could abandon the case. Never been a just termination of just compensation, and therefore take the
contested what his attorney said. There's a lot more.
I guess what I'm trying to figure out is that your argument that it's the final answer that then concludes that it's
Okay, we request that the Court of Appeals be reversed and that your trial be affirmed on the motion to give you a full dismissal and subject to trial for just compensation. It's my name is
Chief Justice Beasley, and may it please the court. My name is Suzanne Todd, and Brennan. We represent the University Financial Properties in this matter. University Financial did not want to sell its property to the City of Charlotte, so the City of Charlotte took it. In this case, the City of Charlotte took title to University Financial's property the instant it filed this condemnation action and made that deposit. When the city took ownership of the property owner took ownership of the deposit.
I hate to interrupt you this quickly, but isn't Mr. Meeker correct in saying that 136 situation here, since you've already got a record, anyway, so I'm just going to go ahead and do it. But, you know, the question is, if the city, 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 it seems to me we're in a situation here where the city files its makes the $575,000. You have the right to take that $575,000 deposit and not ask for a termination of this conversation and walk away. Correct?
That is correct.
Okay, well, what happened here is that you filed a request for a hearing. You answered it and asked for a termination of this conversation. You then wound up litigating an issue that went all the way to this court on discretionary review as to what's completed. And which did not prevail in litigation. And then at that point, you haven't made a decision. Included a component for view-related damages. And your contention is that you ought to be allowed to do that?
That is correct, Your Honor.
Let's
University Financial One said is that it was dealing with a 136-108 motion where really all issues, it was regarding the extent of the taking. As part of the holding, the court did say that if you take this case to trial, you may not present evidence of damages due to loss of visibility. But again, that is the property owner's decision whether or not to take the case to trial. As far as a fairness argue or the windfall argument, I know that is just sort of a hot button word.
Well, obviously, I'm not so far removed from the practice that I don't remember how everybody tried to characterize everybody else's position in a manner that was most favorable to them. That's nothing new.
Absolutely, Your Honor. The as far as if you want equity, if we talk about equities, it is the city of Charlotte who has the ability to decide what property it needs, what property it wants, and what property, how much money it's going to deposit. If there is, in fact, the city of Charlotte obtained an appraisal, they had it reviewed, their council filed condemnation action, and it wasn't until 18 months after University Financial withdrew that money, which is allowed to by statute, that the city said, hey, we changed our mind, we think it's worth less. In the meantime, the instant it has filed its condemnation action, it takes title to our property. And in the same way that Mr. Meeker said, the city cannot reduce once it takes property. It can't undo the taking. In that very same way, once it's made that deposit, it cannot undo that. It cannot reduce that deposit amount, and the statutes are clear on that to protect. So from an equity standpoint, between the property owner who didn't ask for his property to be taken and the city, who had every opportunity to look at their appraisal and decide what they were going to deposit, the tie on that has to go to the property owner. And that's what the statutes intend to protect. And even if there's a change subsequent to the taking, new case law, a change in conditions, a change in value, between the property owner and the city of Charlotte or the government, the property owner has to win. And that's why the statutes have been enacted by the legislature in an effort to protect the property owner's rights. And that is exactly why 136-103 is very clear that you can amend your complaint and your declaration of taking and increase the deposit.
With the statutes just saturating all of this in terms of controlling how it all operates, what's your position on the other side's view that that's yet another reason why Rule 41A is not applicable here, because the nomenclature doesn't set up, you're the defendant, they're the plaintiff. 41A talks about a plaintiff taking a voluntary dismissal, and that general civil procedure rule just doesn't fit a statutory construct such as this.
Well, Your Honor, Justice Morgan, you're correct in that you're right. The condemnation cases are odd. The property owner has the burden of proof. The property owner has the right to trial. The property owner goes first at trial. In all effects, they are the one with the claim. And the condemnation statutes, though comprehensive, do not address every opportunity or every type of procedure. However, what they do address, they do give the opportunity in 136-114 for a judge, trial court, to carry into effect action or some type of conduct, a process or some type of conduct that is not contemplated within the condemnation statutes. And so that is an avenue whereby the trial court could, for instance, allow a voluntary dismissal and perceiving that the plaintiff is actually, or the defendant is actually acting like the plaintiff in the case. The property owner is the one with the claim. I would also point out that Rule 41C talks about dismissals by cross claims, counterclaims, and it so clearly envisions that it's not just the plaintiff. So just because it doesn't say the word defendant, Rule 41C doesn't envision any parties dismissing as well.
So in terms of Rule 41A not exactly fitting in terms of the fact that it somewhat feels like in a way it shoehorns in civil procedure into a statutory provision, nonetheless it feels that the majority is correct here in terms of the fact that although the nomenclature doesn't set up the same way, that a defendant in a case such as this is a plaintiff, and this court should declare a definitive as such.
Does the could mean that there's discretion with regard to how the trial court looks at every different situation?
When a property owner wants to end and done with litigation and wants to get out of a condemnation case that was filed against it, that case law and a lot of the statutes, courts have recognized that the voluntary dismissal is a vehicle where they can really get relief and walk away.
Do we review what the trial court did for abuse of discretion?
Well, it's interesting because the city's position is that 136.115 allowed it through, I guess, to deny allowed it to deny the voluntary dismissal and declare it a nullity through the use of 136.15. 136.15 authorizes the trial court to do something, to carry something into effect. It's not
one of the questions that I was going to ask you, just to follow up and make sure I understand your answer to Justice Newman, is it your argument that the trial court was required absolutely to allow a voluntary dismissal? Or did the trial court have the right to refuse to allow it?
It did not have the authority to even consider. Yes, the voluntary dismissal
But I think the reason that both justices, I know it's the reason I'm asking, and it sounds like it's the reason that really asked about this case, and said a number of times that the trial court which seems to me to be different than the trial court has no role in it. Unfettered right to file a voluntary dismissal and take the entire deposit regardless of what the trial court thought was appropriate.
That's correct.
And just to, if we hold that Rule 41 does apply in these condemnation cases, then your argument would be that you have the right to file a notice, end of story, and end of case.
You're going to have the right to file, property owner should have the right to file voluntary dismissal any time prior to resting this case at trial. And once it hands off to the jury to make a decision on just compensation, it's over.
And that's if we hold that Rule 41 applies to these cases. If we do not hold that it applies strictly, and that it's Section 114 that governs the procedures for this kind of situation, since if it's not specifically addressed in Rule 41 and all of the arguments that the other side has made, then you would agree that Section 114 appears to put it in the discretion of the trial court about how to fashion that procedure.
That is correct. Okay. That is correct. Okay. So I think the preference would be not to allow the property owner to continue on with a claim that it no longer wishes to pursue.
Is there any additional authority other than Combs and the arguments about how these cases work in practicality that would provide an underpinning for this court to hold that Rule 41 does in fact apply to the landowner in a condemnation case?
There are unpublished opinions in the Court of Appeals that do say that it is a vehicle for allowing a property owner to end litigation in a condemnation action. Otherwise, I'm not aware of any.
Okay, thank you. Following on your theory that Rule 41 does apply because the property owner is in the position of a plaintiff here, what's your response to the city's argument that in effect their motion to amend was like a counterclaim? They were counterclaiming for the amount back that they say, in light of the Court of Appeals' first appeal, they're entitled to at this stage. And that in those circumstances where there's a counterclaim pending, the plaintiff doesn't have the automatic right to voluntarily dismiss.
Well, in a situation, in the instant case, the city's filing a motion to amend. Number one, it was filed under Rule 15A, versus filed under 136-103. But the motion to amend in and of itself wouldn't have survived a voluntary dismissal. It might answer. Could you repeat?
Well, I think what I'm trying to understand is everything's flipped, right?
Yes.
And so if Rule 41 applies because you're like the property owner is like a plaintiff, why isn't the city saying, we think the value is less? Why isn't it like a counterclaim to get back the amount of the deposit that they originally received?
Well, and the city, it was not the motion, simply a motion to amend. It is the city cites motion to amend. She took a voluntary dismissal. Basically, they agreed with everything. They were both in the same, or they totally agreed to the same
Why is the city's interest in not paying more than just compensation entitled to some consideration in this process?
Number one, it's the property owner that gets to decide what is just compensation until that time where it hands it on to a jury.
If you have a determination of just compensation, that's done by a jury, isn't it?
Well, it is up to the property owner.
I mean, in theory, neither party gets the right to unilaterally determine what just compensation is. Both of you have a chance to put in a typical case, both of you have a chance to put your evidence up and have a finder of fact, typically a jury, decide what the just compensation amount is, right?
Well, the property owner should have the right to be able to accept the deposit as just compensation right up until they hand that off to a jury.
Even if circumstances that affect the calculation of that just compensation change in the interim.
That is correct. There's always risk when you you file a condemnation action and instantly take title to the property.
I mean, there's risk everywhere, assuming the city's position is correct. It took the risk, it made a mistake as to what the just compensation amount used to determine deposit was. You could have taken the deposit at that point, and I don't think Mr. Meeker contends if you had done that, he would have had the right to come back and try to get some of it back from you. It may be countervailing risk both ways, aren't it?
Well, but if the property owner, I think what the city is saying is that once you file your answer, the gloves come off, and they may withdraw that deposit. Again, they already have. This is not a voluntary purchase and sale negotiation. They already.
Well, I think that's probably one of the few things we could all agree on.
Follow up in a more open-ended way. So much seems to be automatic here in terms of looking at how your position is. Once the governmental entity files the complaint, title automatically goes to it. That's automatic. You say, therefore, that there's an automatic entitlement to the deposit to withdraw it, and there's nothing that can be done to contest that.
Correct.
Then there can also be a voluntary dismissal by someone in your client's position, and that's automatic. With all this that's automatically done without a court needing to be involved at this stage, where would the aspect of the determination of just compensation come in, or does everybody just retreat to their respective corners, to use that colloquialism, and nothing else can be done because all of this has been so automated that there's no room for anything else?
Well, I do have to say that there is no mechanism in the statutes for ending the case, so yes, it would require the judge's discretion as far as requesting or approving a voluntary dismissal to some degree. But I do think, in a sense, it is what those condemnation statutes are all about. They are there to protect the property owner, and it is rather automated. And if the property owner does not decide to pursue a claim for additional compensation, then the case is over. They can simply accept, under 136-107, they can simply accept the deposit made as just compensation, and the court enters final judgment.
So to follow that to its logical conclusion, if there is a good faith deposit that's made by the governmental entity, and later on it is determined that there is some intervening factor, such as here, the Court of Appeals opinion, that the visibility was not impaired so as to be just compensation, then the governmental entity is just out of luck because of the fact that the landowner seized upon the opportunity to automatically withdraw the deposit, close the window on the case through voluntary dismissal, and that's it.
Yes, Your Honor. Sometimes there's, between the property owner and the government, the property owner owning its property, going on about its day, and the city with the ability to condemn, there has to be a limit. There has to be some sort of check and balance on the sovereign's authority. And that is why 136-103 specifically says they can amend their complaint and declaration they can increase the deposit, but it doesn't say anything about allowing them to decrease the deposit. Between the two, it has to be, the city has to be the one that shoulders the burden when something goes wrong.
Before the time's gone, I have a quick question. Under these circumstances, if we apply Rule 41, you take the amount of the deposit, take cases over, and something happens after that within a year to really, really increase the value of the property, are you contending that you would have a right to reopen the claim under Rule 41A?
No, we would not. No, once a property owner takes voluntary dismissal, the case is over. It does not have the...
But the rule provides that you could.
Well,
So we're supposed to apply part of the rule, but not all the rule?
Well, I think the rule should be that in a condemnation action, when a property owner takes a voluntary dismissal, that does, just like the court in Coombs says, that acts to be an acknowledgement that the deposit is just compensation, and that they do not have the right to bring back their claim a year later. So you're correct. Condemnation is forcible taking of private property. It's not a negotiation. These condemnation statutes are all that stands between us and the people, or between us and a government that thinks this is a voluntary transaction. The Court of Appeals got it right when it concluded that a property owner has the ability to end litigation in a condemnation case by taking a voluntary dismissal. And in holding that the city cannot amend its complaint to reduce its deposit, demand jury trial, or return any overage on behalf of University Financial, the landowners in this courtroom and across the state, we respectfully ask this court to preserve the protections afforded by the statutes and affirm the Court of Appeals holding. Thank you.
Did you know that nearly 50 million Americans struggle with hearing loss? I'm 78, but I can hear like I was 27. Let me show you.
obligated to retain an employee who has used the N-word to describe a DSS client's race while conducting her duties as the Child Protective Services supervisor. We ask this court to hold that the DSS was not required to retain the petitioner because her use of the N-word in this setting is contrary to the department's core mission, policies, and principles. It is demeaning to the very population the department is required to protect, and such language eroded the department's ability to trust its employees' judgment. Because the Currituck County met its burden of proof, the Court of Appeals decision should be reversed. Under the applicable State Personnel Act, an employee such as the petitioner has a right to not be disciplined, including dismissed disciplinary actions without just cause. This court, in its Carroll decision more recently, in its Weatherton decision, set out that that means whether there's just cause to dismiss disciplinary action taken. This court has set out that that question is answered with a two-pronged test. The first test is whether or not the petitioner's conduct under the circumstances, whether her conduct amounted to unacceptable personal conduct.
Yeah.
This question is also not needed to be answered by this court, as it's already been decided by the Court of Appeals. The Court of Appeals held that the department met its burden of showing that the petitioner's conduct under these circumstances rose to the level of unacceptable personal conduct for the following three reasons. One, her conduct was such that no reasonable person would expect to receive prior warning. Two, her conduct was a willful violation of known work rules. And three, her conduct to dismiss an employee. Flexible standard deprives management of its discretion. The discipline imposed. as it goes through and weighs whether or not discipline selected was just, is de novo review. No deference is required to the Court of Appeals consideration of the factors or to the administrative law judge's consideration of these factors. In order to understand and to help this court as it goes through the factors to determine whether dismissal was just, it's important to understand what the petitioner's job was, what her duties were, and the very stakes, the lives that were at stake based on her job duties. What I mean by that, the petitioner was the supervisor of the department's Child Protective Services. She sat second in command when the director was out. She served as the face of the department. She took in and screened all calls of child abuse and neglect in that county. It was her role to oversee other social workers' investigations as to whether child abuse and neglect had occurred. She weighed the credibility of witnesses. She weighed the credibility of these children's complaints. She played a key role in making determinations whether a child should be removed from the home, whether the child abuse had been substantiated. And she often served as the department's witness in the district setting when the court deciding whether to remove the child from the home. In this county's Child Protective Services Division, the department was required to protect children with significant from minority populations, including Black and Hispanic children. The department already faces and struggles to overcome minority families' lack of trust in the system and lack of trust in the process that they go through in their child's decisions. In order to address some of these obstacles that the department faces, the department, the state, and the federal government have policies, rules, and laws that will address some of these concerns that the minority families have. For example, the department had a specific rule that its social workers were not allowed to use racial epithets at the workplace. They were not allowed to use racially demeaning language in the workplace. They were required to administer their services to the families without regard to race or cultural differences. They were required to go through training to assure that they understood their obligations with respect to neutrality. In order to receive federal funding, this department had to certify that it employed employees and social workers that would abide by these very principles and this very mission that the department held. The petitioner was a tenured employee, had been employed over 10 years with this county as a social worker. She was fully aware of the importance of these policies and procedures. She was fully aware of the importance of the harm that could cause if she violated these policies and procedures. And she herself had received the training on numerous occasions throughout her career. Currituck County's Department of Social Services mission of protecting these vulnerable populations from abuse was expressly dependent on its social workers and specifically petitioner heirs to remain unbiased, non-discriminatory, and fair at all times. It is critical as a guardian of these children's welfare that the social worker and the department remain neutral at all times. The consequences of a social worker specifically working in the Child Protective Services Division demonstrating a lack of neutrality is serious, because the determination whether a child can safely remain in the home or must be removed from the home often turned on petitioner heirs' judgment. On November the 2nd, 2017, petitioner heirs broke her solemn obligation to remain racially neutral. She used the N-word to describe the race of a family she was charged with protecting.
Wow.
As part of the obligation of the director to gather racial demographic information for required reporting purposes, she ran across one of Petitioner Ayers' clients who had on the racial line the initials NR. Not familiar with that racial demarcation, NR, the director went to the petitioner to ask her, what is the race of this family? What does NR represent for their race? We now know that meant not recorded, but Petitioner Ayers, the supervisor of the Child Protective Services Division, answered the director's question in her office with the door open, with her subordinates closely down the hall, some of which were African-American social workers. She answered the question, the first word that came to her mind to answer what that N stood for. She wasn't under duress, she wasn't under provocation, and she had not been prompted. The first word was her to utter the word N-I-G-G-E-R. She answered what the R stood for was Rican, like Puerto Rican. Subsequently, she testified that the N word came to her from her, quote, personal word bank. The R came from her brother-in-law's use and stereotyping her words of Hispanic individuals. He would refer to all Hispanic people as Ricans, like Puerto Rican. As soon as she uttered this phrase to the director of the department, she revealed her inherent bias and cultural prejudice. The director, shocked, offended, took several days to determine, after consulting with experts, what possible disciplines would be appropriate for this supervisor, this tenured employee who should have known better, the use of this language in the workplace. After considering all factors, the department had determined that she had just cause to terminate the petitioner under these circumstances. Moving to the 5 factors that she considered. First, the consideration of whether discipline that DSS imposed in other cases involving similar violations. There had never been another piece of conduct in this department involving similar violations. No other employee had ever used racial slurs or used racially demeaning language that needed discipline. Thus, because there's no other similar violation, this factor need not be considered further. Next, considering the subject matter involved. A social worker's racially discriminatory language used at the workplace to identify the race of a DSS family is the subject matter. Specifically, the subject matter involves a social worker supervisor's use of the N-word to describe the race, identify the race of one of the families she serves. The subject matter is probably best described by Judge Collins in her dissenting opinion when she quotes the Fourth Circuit's comments on the use of N-word. Quote, far more than a mere offensive utterance, the N-I-G-G-E-R word is a pure anathema to African Americans. Perhaps no single act can more quickly alter the conditions of employment and create an abusive working environment than the use of this racial epithet. Moving to the consideration of the severity of the conduct. The conduct was so severe precisely because of the subject matter involved. The rule states that an employee may be dismissed for a single act of unacceptable personal conduct without any prior discipline, action taken. The employee doesn't have to have a record of disciplinary actions in her personnel file. She doesn't have to have received prior warning for dismissal to be appropriate. Here, the petitioner's conduct was so severe that even a single act calls for dismissal. To illustrate the severity of the conduct, as an officer of the court, I don't even feel comfortable enough uttering the words she used to her supervisor when she described and identified the race of the family that she was in charge of. The ALJ and the Court of Appeals appropriately concluded, quoting the Fourth Circuit statements, that the mere utterance creates an abusive working and personal environment. Quote in the Fannie Mae decision, where Justice Kavanaugh was a concurring opinion, quote, no other word in the English language so powerfully or instantly calls to mind our country's long and brutal struggle to overcome racism. African-American social worker Tiffany Sutton provided testimony at the hearing of this case. When she heard that the petitioner had used this language, she stated to the ALJ, the people that work at this agency are supposed to be different. The agency is supposed to hold itself with high standards, with core values that do not involve using racial epithets. Use of a racial epithet leaves a stain on this agency. Given the severity of the violation, the very subject matter that involves, these factors weigh in favor of dismissal. Next, considering whether the conduct resulted in potential harm and whether the conduct resulted in actual harm. First, there is no requirement that the department must show that there was actual harm. This court, both in his last two decisions, has held that the only thing that the department has to do is to consider whether there was actual harm. In this case, however, we know that both actual harm and potential harm were suffered as a result of this conduct. The Court of Appeals correctly concluded that the potential for harm was significant. The potential for harm in her role in this division, for this state agency is endless. To creating a hostile work environment, to ruining the department's reputation, to harming morale within the department, to having her subordinates losing all trust in her judgment, to creating civil liability, to jeopardizing the very federal funding that it was required to function. The petitioner's use of this language to identify the race of one of the families that the department was required to protect demonstrated her lack of neutrality. Even the perception that its social work operation would damage her reputation. she also appealed it, stating that she didn't feel that while she may be sorry, it wasn't cannot be that the DSS employer is required to keep an employee. It now has knowledge, is willing to pull this language out of her personal word bank, knowing and understanding how harmful the language is, especially in this setting. And the practical effect of this court affirming the Court of Appeals, if the employee is a tenured employee and she has a clean record, the employer cannot terminate her for using the N-word, even regardless of whether and what effect it had on the mission of the department, the service that it provides, the principles it stands for, her willful violation of the policies, the erosion that her department ability to trust her moving forward because she just said it once. That cannot be the standard. We ask that you that you reverse the Court of Appeals decision and uphold the department's decision in its determination that it did have just cause when it decided to terminate this employee for this conduct.
Thank you, counsel. We'll go from the appellee.
Chief Justice, Associate Justices, may it please the court. I'm John Leidy from the Pasquotank County Bar, and I represent the appellee, Judith Ayers, in this case. And we're here today because 7.5 years ago, the Department of Social Services decided to terminate Ms. Ayers because she used a racial slur. But she did this in a private conversation that was not heard by any subordinate and not heard by any client, not heard by any third party, heard only by her white supervisor, who then decided to terminate her without considering whether anyone else heard this incident, whether the department had suffered any harm, and without conducting the analysis that is required by this court's decision in Wetherington versus Department of Public Safety. In addition, this decision to terminate Ms. Ayers 7.5 years ago was motivated by the personal bias that the director had against Ms. Ayers and the history of some professional conflicts that they had had. And because the department has persisted in trying to justify its original decision instead of engaging in meaningful and required analysis of the evidence, we are here today. We're here because there was a dissent from the Court of Appeals' latest decision of 3 decisions entered in this case. And in that dissent, there were 2 points that were raised. And those are what should frame this appeal today. The first is whether there was a sufficient showing of actual and or potential harm to support dismissal based on the Wetherington analysis. And secondly, whether the administrative law judge erred in considering discipline in other cases because there had never been an identical violation in the past. This court should reject the department's arguments on those 2 points for at least 4 reasons. First, DSS failed to establish that any actual harm resulted from the unacceptable personal conduct. Secondly, actual harm is required by the Wetherington standard. Third, even if this court were to find that potential harm is pertinent under the Wetherington analysis, the minimal risk resulting harm does not apply to this. And then as to the consideration of discipline, the ALJ properly considered discipline.
Incredibly troubling lack of judgment on that DSS worker, that's a situation where potential harm is really justifies the discipline.
Justice Riggs, the Court of Appeals has applied that test. This court has only used the language in the Wetherington case that the harm resulting from the conduct. And so, based on the language of the prior decisions in this court, we feel that actual harm must be shown. Don't disagree that there can be the potential for harm, and that, and particularly in this case, the Court of Appeals, the majority found that there was a risk of significant harm, but that the risk was minimal. But we believe that whether you look at an actual harm or potential harm standard doesn't change the outcome in this case. But our position remains that based on this court's precedents, actual harm is what the standard is that the department should be held to make it showing.
Okay, and so understanding that position that you're taking and the ALJ's findings, would you agree with me that there's a distinction between what the ALJ found as a matter of fact was her subjective intent to repeat or not repeat, issuing a racial epithet, versus this judgment question of like, this is part of her discourse, and she, is sort of talking about it as a joke as opposed to something serious. Like, can you see the difference where I might understand that the ALJ is in a position to make a fact finding about her subjective intent, but there's still this larger judgment question that isn't really covered by her subjective intent?
I agree. Those are two different things, and I think it's incumbent on the department to consider both of those in addition to other things. As it is, the ALJ in this case did consider both and found that both weighed against the issuance of dismissal for the conduct in this case, in part because while on the judgment issue, the administrative law judge found that Ms. Ayers had a spotless performance record. She had never been disciplined, that her performance had always been evaluated at the highest levels, that she had been a trusted, loyal, effective, and professional employee, and that there was no realistic expectation that she would be disciplined. So, it is what
essentially her conduct didn't rise to the level of a dismissible offense.
Justice Allen, I disagree with that assertion by my colleague. We have not contended that she should not be disciplined. In fact, we have not challenged the 2-week suspension without pay that she was issued following the initial remand from the Court of Appeals. We do not challenge that. Ms. Ayers is prepared to accept that. She's prepared to accept the additional training that's been directed. She's prepared to accept punishment for this. We have not contended that she shouldn't be punished. We've contended that the department failed to establish just cause for dismissal in this case. That's all we've argued. So if I may go on to talk about the dissent's discussion of harm, because I think this really gets to the meat of this case. The dissent asserted that there were 5 different things that it considered to be harm that would have supported dismissal in this case. I'm going to go through those in order. The first was that the conduct eroded the director's trust in Ayers' motives and judgment, which is what we've just been talking about. The majority found, just like the ALJ found, that this was only potential of the ALJ found that the department could not reasonably presume that this one unacceptable personal conduct from Ms. Ayers would have a future racial outburst which would create some sort of risk of perjury. ALJ found and believed to be unreasonable, unsubstantiated, speculative. This might be the judge found, so the ALJ found that it was not supported by the evidence. It was contrary to the undisputed findings because the director would have the ALJ to stop his disciplinary history, history of excellent performance, and accuracy, and consistently express rules. Freaking cowards! Whether it's reasonable to expect the ALJ also found that Herb's determination on this issue was more influenced by freaking cowards! They're gutless! They're not here! The colleague in this case, in interviewing, did not challenge that finding. They have not challenged the ALJ's consideration of bias and motivated pursuit. And finally, although the department has argued that Ms. Ayers wasn't remorseful, the ALJ turned from the evidence that Ms. Ayers was always been remorseful. The second assertion is about harm. Okay, I'm bored in the house, bored in the house. This actually resulted from the co-worker's position actually the department's disclosure.
Officer put innocent people in danger. The body cam video shows people in the parking lot. Some
campus, also the Confederate monument outside the Durham County Courthouse, and that
Start making
issued an order remanding the case to DSS to do another investigation on November the 5th. On January the 19th, counsel for the department issued a status report saying it was prepared to make a showing on harm to the agency.
I'm being told by a source in New York
on March the 3rd that directed DSS to issue an amended final decision to give Ms. Ayers an opportunity to respond to it. And only then did Ms. Hurd decide to interview the other employee that was there at the time of the incident. Only then asked her whether she heard the comment when it was made or whether she had heard about it. This was 5 months after the Court of Appeals had ruled that the investigation was inadequate, that further investigation was required, and this was nearly 5 years after the decision to dismiss Ms. Ayers. So all of that reflects an unwillingness or a disinterest on the part of the department to really consider the issue of harm in this case. Regardless, the ALJ found that Ms. Sutton was unable to say when she learned of the conduct, including whether it was before the department made the disclosure to a coworker in preparing for hearing, or it was because of or after its first opinion in this case, which recited the actual conduct itself. They also found that no one outside the process, other than had any knowledge of the incident until Ms. Hurd disclosed it to coworker Phelps in April of 2018 when preparing.
How should we look at that fact as it relates to harm?
That would demonstrate the harm. And I think it certainly goes against the finding of any harm to the agency because no one outside of the agency knew about it. It was a confidential personnel matter. Ms. Hurd, the director, was obligated to keep it confidential. And so at the time, going back to November of 2017 when this incident occurred, there had been no
on the UNC campus, also the Confederate Monument.
I'm going to talk about potential harm in a second, but taking potential harm out of it, there had been no harm to the agency whatsoever at the time that the decision to dismiss was made. That's contrary.
New tonight, the Raleigh man targeted by Russian.
So, going on to the third.
New tonight, the Raleigh man targeted by.
On the harm issue, DSS has policies prohibiting the use of demeaning or inappropriate terms or epithets in telling off-color jokes regarding race. But this disregards the fact that it has been unable to prove that it has a policy that so provides. In fact, the ALJ found that there was no policy that was violated by this conduct because the policy that DSS has requires that an act of unlawful harassment be targeted to somebody who is the object or subject of the harassment. And in this particular case, there was no such object. The ALJ also found, and this is an important component that is contrary to what you heard a moment ago in the opening argument, but the ALJ found that Ms. Ayers did not know the family in issue, did not know their ethnicity, and was not referring to their ethnicity when she made the decision. She was only trying to solve a word problem with the initials NR meant because it was not something that was a recognized or common abbreviation in the department. And she said that she just blurted it out. Trying to figure out what those mean. And that's different than characterizing the family or describing the family. The ALJ has never found that she was referring to the family or knew anything about the family's ethnicity. Without that kind of proof, the department failed to prove that the policy was violated. Similarly, the dissent says that the department has a duty to enforce these policies and to further its goals of supporting parents by respecting each family's cultural, racial, and ethnic heritage. Again, the absence of any particular policy or the failure by the department to show that any policy was violated undermines or refutes that ground. And the last assertion that the dissent made is that Ayers' conduct exposed the department to vulnerability for negligent retention and supervision liability and its compliance with Title VII. This assertion is made completely without
any analysis or citation to case law. In fact, it's contrary to case law. We've discussed cases in pages 30 through 31 of our brief that explain what needs to be shown in order to provide negligent retention or negligent supervision liability, and that has not been shown here. The majority found that, in fact, that assertion was contrary to other evidence and other findings in this case, particularly that the conduct was an aberrant and unintended event, that this was a momentary lapse of judgment by a highly effective and professional employee, that she immediately showed remorse, that she has consistently and continually expressed remorse. The ALJ found that after hearing her testify on 2 separate occasions, 4 years apart, that this was that she had never engaged in misconduct before, and that this was not part of a pattern of misconduct. So, you know, all of that refutes the idea that raised by the dissent that this somehow created vulnerability or potential liability for the department. So going on to the issue of potential harm, as I said, this court's decision in Wetherington requires an analysis of actual resulting harm. Even if this court were inclined to accept that potential harm can meet that standard, we say that this is not the case to announce that rule, because here the risk of potential harm was minimal. That's what the ALJ found. That's what the majority found. We think that's absolutely correct. Contrary to the department, the ALJ and the majority opinion did consider potential harm and found that much of the potential harm was speculative, based only on Ms. Hurd's subjective belief, or was contrary to or otherwise refuted by the passage of nearly 5 years since the dismissal. The other point that was raised by the dissent, as I mentioned, deals with the consideration of discipline in other cases. I think this is actually a pretty important consideration. The department's argument in their briefs on this really disregards, or at least is a departure from, the Wetherington standard. Wetherington makes clear that just cause analysis requires consideration of discipline that has been imposed for similar violations. This does not require that the violations be identical. Consideration is consistent with, and we think even necessary under this court's decision in the Division of Environmental and Natural Resources versus Carroll case. Carroll is the one that, in fact, my colleague referenced it a moment ago, but it makes clear, it was decided before Wetherington, it makes clear that the consideration of just cause for disciplinary action is a flexible standard and depends on the nature and the specific facts of each case. Here, DSS has cited, and the dissent cited, no authority supporting their argument that because there was no identical misconduct in the past, that prior discipline shouldn't be considered. From our research, there is no authority for that point. The dissent includes no discussion of the Carroll case. The department has not meaningfully distinguished Carroll, and yet Carroll is very, very applicable to our case. It's important to consider that at the Department of Social Services, prior discipline has only been imposed after a pattern of misconduct or repeated acts of misconduct. So, you know, given that background of the way discipline has been administered at DSS, we feel that the fact that this was a one-time isolated occurrence, not part of a pattern, that is in fact relevant. So we think that it's off base for the department to argue that it should not have been considered. This, I think I'm going to just go ahead and conclude my argument, because I think the parties have adequately briefed their positions. But I want to say that at this point, this case has rifled down to a very narrow set of issues. We have had 2 full-day evidentiary hearings in this case, separated by about 4 years. As I said, we've had 3 trips to the Court of Appeals. Each of those appellate decisions resulted in 2 different opinions. The first 2 appeals had concurring opinions, and the most recent appeal had a dissent. And we're here because there was a dissent. But the department failed to start this whole journey off correctly. Ms. Hurd gave no consideration to whether there was any harm to the agency. She didn't consider it. She didn't think it was important. In fact, when the case went to the Court of Appeals on the second occasion, the reversal at that point was because there had been no investigation of harm, and it was remanded to have that done. That was all because Ms. Hurd did not think harm mattered. Instead, she thought she could terminate Ms. Ayers based on her motivation and personal bias against her. And since then, she has persisted in trying to justify the dismissal when a proper application of Wetherington and the analysis of whether just cause existed for dismissal should have been followed. The Department of Social Services and its director have been oblivious to the need to consider or show resulting harm, as Ms. Hurd has doggedly tried to justify her decision. The ALJ found as much. There was a finding in the case to that effect. And for all of those reasons, we contend that this court should affirm the result from the majority in the appeal below and affirm the relief that has been awarded to Ms. Ayers. And unless there are further questions for me, I have nothing further to say.
Thank you, counsel.
Thank you, Chief Justice. Thank you, Associate Justices.
Rebuttal?
Yes, Your Honor. First of all, there is no requirement that there be actual harm. This court has held that the only requirement is that there be a consideration of whether there was actual harm. There is no precedent by this court or any court of appeals or any other court looking at these issues that state that actual harm is required. Regardless, however, there was actual harm caused by this conduct. The petitioner's view and definition of what amounts to actual harm is just too narrow. Under these circumstances, considering what's at stake and the language used revealed to anybody hearing the conduct or the language that there was a lack of neutrality.
Also, what about your friend's argument that the conduct here was not disclosed to anyone and that the harm resulted from Ms. Hurd's disclosure?
So, first of all, Ms. Hurd heard it. The supervisor heard it. The person who is required to assess whether or not their social workers are operating in a neutral, non-biased way heard it. She was personally offended by it. And again, what we're talking about is the mission, the ability to remain neutral, the ability not to be discriminatory in the petitioner's role. She is the social worker that is required to assess child neglect. Her uttering that word, even if it was just once, even if it was just privately to one other person, revealed her bias. And it's reasonable for any director or for anyone overhearing that utterance. She wasn't provoked. This wasn't under duress. And her uttering that showed how she might approach the role she played in investigating these matters. The stakes were too high. We could not have the petitioner in her role making the decisions about and potentially being persuaded by the family's race or the witness's race. We could not have that a part of our assessment. And that was the harm. That's the harm. Whether or not there was harm, whether another social worker heard it, another subordinate heard it, is irrelevant, given the division we're talking about and her position in her role. And just briefly, she has disputed whether her conduct amounted to unprofessional conduct. It's in their brief set on page 7. She states that her conduct did not warrant any discipline. In her appeal on page 5 of the record, she indicated that these facts do not amount to unacceptable personal conduct. That, coupled with the gravity and the severity of what she said, absolutely show and corroborate the bias that she brought with her to her job. Doesn't matter whether she's going to say this word out loud again. It doesn't matter whether she said it and she got caught and was upset and remorseful. What matters is we know this is now in her thought process. And for that reason, Your Honor, we would ask that the Court of Appeals be reversed. Thank you. Thank you.
It's not having access to 1 million industrial-grade products that's so amazing. It's the feeling of knowing you'll find the one.
Before the court on the state's notice of appeal based on Judge Tyson's dissenting opinion. The Court of Appeals majority erroneously determined that the trial court erred by excluding a note by Hazel that was written at some unknown time prior to her running away from home on April the 25th, 2020. The undated note describing a past and fictitious event was irrelevant, speculative, confusing, misleading, and prejudicial. The trial court did not abuse its discretion by excluding the note. At trial and during cross-examination, the defendant sought to introduce this undated note that Hazel identified as being in her handwriting. He attempted to introduce it as Defendant's Exhibit 1. The defendant argued that the note presented an alternate explanation that Hazel ran away from home to be with Larry rather than running away from home due to defendant's sexual abuse. The defendant did not seek to omit the note to show that Hazel made up fictional stories or fantasies, or that the allegations were one of her fictional stories or fantasies. Events that truly occurred. Hazel admitted the note was written in her handwriting, however, she stated that she did not recall writing it. She wrote about record evidence shows that the trial court conducted a very thorough review The trial court also heard arguments from both parties and determined that the evidence had no evidentiary value.
Didn't the trial court misstate the Rule 403 test? And don't we have a lot of case law that says that along with the state is an abuse of discretion?
Your Honor, the trial court did not include the word substantially in stating the Rule 403 value. However, the trial court did state that there was no evidentiary value for this evidence at all. And it's the state's contention that the trial court properly balanced it, and by determining that there was no evidentiary value, the trial court in essence determined that the prejudicial effect outweighed any substantially outweighed the purpose value, because the ruling was that it had no evidentiary value. Even considering...
Just so I understand your position, the reasoning is because the trial court said no evidentiary value, it wouldn't necessarily cover the value of substantially outweighed.
That is correct. The trial court made a ruling, and it's the state's contention that the trial court did not utilize the word substantially in making that ruling determination that the prejudicial effect was
outweigh the probative value. But the trial court in that same ruling also determined that it had no evidentiary value at all. And by doing so, it's our position that if the trial court determines that a piece of evidence has no evidentiary value, then the prejudicial effect of that evidence does substantially outweigh its probative value. It has no evidentiary value at all. And I think what's most important here is the defendant's basis for asserting or seeking to admit the evidence, even to overcome Rule 401 before we even get to the ballot.
Do you agree with the trial court that there is no evidentiary value?
As presented. As the defendant presented the evidence, the trial court did with the verdict. The defendant here, and I know that the defendant makes additional arguments, the majority actually brought up additional arguments. However, looking at the transcript and how the defendant presented his argument, he presented it solely to show an alternate explanation for her running away from home. And looking at the note itself, it's on page 150 of the record, she stated, it's in quotation marks, it's written in past tense, asked to indicate, as the trial court indicated in the consent vote, indicated that will indicate the past information of events that had already occurred, and that the note, she never returned to the home, even though the note was on the home after 18. So as proffered, no. It was intended as a component of the evidence to establish a basis for the admissibility of this evidence. The defendant argued in his brief to this court that it could show that she makes up stories, and this is one of those stories. However, that was not the argument for the trial court. The argument for the trial court was the alternate explanation. And the defendant, through his cross-examination, also sought to establish that, well, did he have any dishes when he had the flu? That defendant was a bad man, and she saw him as a bad man, so therefore that's why she was running away from him. However, I think the defendant also has issues with Rule 401 because even that evidence as proffered, what does it show? It shows at some point in time, we don't know when because it's undated, the victim wrote this note prior to April 25th, 2020, about exiting the house to go with a boyfriend named Larry. So even if we assume that everything said in the note is true and that it had been admitted to the court before the jury, it would only show that she exited the room, and she made this prior. No explanation for that. This is a fictitious note, and she admitted that she wrote the note about because we don't want to wake Jackie's asleep. So I think that's additional cooperation to show that this was a fictitious note.
The defense counsel argued that unless that evidence is true. Is that right, that you can't use a prior statement as impeachment evidence unless the statement is true?
I think what's important is, I think what the trial court was getting at, the fact that how do you impeach someone with something when you cannot prove the veracity of the information in which you're impeaching them with? In this particular note, as written, as with quotation marks and in past tense, he could not establish anything with that. He did not articulate a basis for that either.
But can't you use impeachment, a prior statement as impeachment simply to show inconsistency without having to show that the one statement's true and the other statement's false?
I would agree with that. However, in this particular case, the inconsistencies were all before the jury. This was cumulative evidence.
What I'm getting at is, with this question and my prior question about the standard is, we have a trial court that really sort of is misunderstanding what legal rules apply to this analysis?
I guess if you're asking me, I guess my opinion on do I believe that he misunderstood it? I would say no, based on the record. The record shows that he properly conducted the 403 analysis. It properly shows that he balanced it. And it was the misstate of that one magic word substantially in his analysis. Because I think also, going back to the defendant is the proponent of the evidence. So it's the defendant's job to bring the issue to the trial court. So I think that's why the trial court is having so many issues with this. And in fact, the trial court stated, I haven't got there yet. The defendant didn't provide that sufficient basis. I think the Court of Appeals majority, in its opinion, stated that the evidence had probative value for two reasons: to show lack of credibility, and also to show an alternative perpetrator, which that gets into 412. However, no one wants to talk about 412. In fact, the Court of Appeals dropped a footnote in their opinion to state that this case is not about 412. However, their opinion is completely inconsistent by the mere fact that they stated that it can show an alternative perpetrator. So how do you show an alternative perpetrator of the sexual abuse without getting into 412? In this particular case, there were physical findings. The nurse practitioner testified as to the physical findings to her that she had a transection in her hymen that went to the floor of her vagina internally. There was an opinion rendered by this nurse practitioner who opined that this was consistent with sexual abuse. So this note, what other purpose did the defendant seek to admit this evidence? That's the purpose. The Court of Appeals stated it. However, the defendant attempted to circumvent 412 to get this under another basis, but could not sufficiently articulate that basis without getting around 412. Now, the Court of Appeals majority...
Getting back to the impeachment question, what, in your view, what was it that in the trial court's view, it thought was the purpose of the impeachment? What statements did HL make that were being impeached by this? Because the court seems to understand that that was one of the purposes.
The basis in which the defendant presented it to show that she did not run away because of defendant's sexual abuse, but she ran away due to Larry, or going to see Larry. And that would be the purpose of the note, as the defendant proffered it.
But couldn't the court also understand this more broadly, that it's her testimony that she doesn't run away? She'd never before run away.
That is correct.
And it would be relevant. It seems to me there's evidentiary value there. Because one way or the other, the jury would think about the fact that she had written this note, whether it was just something she's dreaming about or if she actually did it. It would seem to be relevant to the question of whether she was telling the truth now. So,
well, I don't think that's a fact of consequence that was at issue here, because the reason she ran away was of no consequence here. It wasn't the primary issue. And the Court of Appeals majority, I think, clearly stated that really wasn't the issue as to the reason why, even though that was the defendant's basis for his proffer. So I think that's the issue that's before this court, and that the issue that was before the trial court. The defendant did not make a sufficient proffer for the basis that he sought to admit the evidence.
So, as I understand the transcript and the defendant's proffer for impeachment, he's saying that he wants to introduce the note because she has testified that she never snuck out before. Not the reason, or even if the note's true, but she testified that she never snuck out before. And he wants to question her about this note because it could imply that she had snuck out before.
And I do understand your question, Your Honor. Again, that fact is of no consequence in this particular case. He established, meaning defendant's counsel cross-examined her thoroughly as to her reasons for sneaking out. He asked her multiple questions about, well, didn't you sneak out because your dad is mean? No. And he kind of continued along that line for pages of the transcript. So that was thoroughly before the jury. In addition, if it comes down to credibility, as the Court of Appeals majority points out, it her credibility was not good. She was, the evidence showed that she was a liar and that she lied 10 to 11 times during cross-examination from pages 131 of the transcript, 134, 135, 136, 137, 138, 140, 146, and 147. 10 to 11 times she admitted to prior instances where she lied. So that evidence was cumulative, would have been cumulative. She was established as a liar. That was the evidence that the jury had, and that was the evidence that they had before them. And the trial court instructed them as to their duty to weigh the credibility. The defendant testified here. So we also have to remember that they had an opportunity to observe his credibility as well. In observing her credibility, his credibility, regardless of the fact that those 10 to 11 times, in addition, an officer of the law testified that she actually lied to him during an initial report, an officer of the law. While she was trying to make a report of sexual abuse, she lied multiple times about her name, her date of birth, her age, the reason why she was where she was at the neighbor's house. She lied to Officer Priest multiple times, and that was before the jury. So I don't think there was any question that she was a liar. Her credibility was open, and it was very clear that she was not credible. However,
does that go more to the question of prejudice than whether or not it was error to exclude questions about the note?
It definitely goes to prejudice, Your Honor, yes. However, I think it also goes to the 403 analysis because it would be the needless presentation of cumulative evidence. Again, it would have been cumulative, and the question becomes, what would it have added here versus the prejudicial effect of allowing the jury to infer that she had sex with Larry. And see, that's the elephant in the room here. That no one's mentioning sexual activity, no one's mentioning that she slept with Larry. Why? Why is that? The Court of Appeals let us know. They stated in their majority that it was for two purposes. One, lack of credibility, and two, as to an alternate perpetrator. And that was the real basis for this. The defendant did not present it as that because the state had filed a motion in limine to exclude this evidence. Could also be because the defendant did not make application under Rule 412 to get this evidence admitted. So the Court of Appeals majority pointed out that would be something for the state to raise. The state did raise it in a motion in limine. The defendant did not make application for it prior to trial, and the defendant did not meet the exceptions. So this is an attempt, and I think it's a clear attempt to backdoor Rule 412. Because for what other purpose did it show? The purpose that he stated, a reasonable explanation for why, an alternative explanation as to why she left home. Well, he cross-examined her thoroughly on that. Or this alternate perpetrator to explain those physical findings that a nurse opined was consistent with sexual abuse or sexual assault that could not have came from masturbation. So that was the reason. And considering all of the evidence, physical findings indicative of the heel hymenal injury that corroborated her testimony, there is not a reasonable possibility that the jury would have reached a different result. If there are no other questions, the state will reserve the remainder of its time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Good morning. May it please the court. Excuse me. I'm Candace Washington, and I'm an assistant appellate defender. I'm here representing the appellee, Mr. Leo. So this case was all about credibility. There was no physical evidence that identified Mr. Leo as the perpetrator of the alleged crimes, and Mr. Leo denied the allegations against him. Michelle's testimony was the only direct evidence on the ultimate issue at trial. emphasized that she clearly makes up stories based on the people in her life, right? I think most of his closing argument was about the fact that, she told lies, and consider, she told that this story because she was mad that he canceled her sleepover. But the actual line of questioning and cross-examination would have driven his point home that she not only tells like little lies, she actually makes up these whole fictional stories based on the people in her life. And maybe these allegations are one of her made-up stories.
So what would the note have, what arguments would have been made specifically from the note? I mean, that she lived with her aunt, that she didn't live with her aunt, that, your friend has argued that, well, the real purpose of this was to try to get another potential perpetrator for the physical injury before the jury. How do you respond to those?
So he never argued that it was to show an alternative perpetrator. And the note, like I said, it goes to the believability as a witness. So we have her on voir dire explaining the note, right? She said that sometimes she makes up stories based on the people in her life. This could have been a story or a dream. So that's what he would have been able to argue to the jury.
Could he have asked her, I'm sorry, I know I'm interrupting, but could he have asked her, do you make up stories?
You mean with or without the note?
Without the note. Just, isn't it true that you make up stories? And if she says no, you've got a different aspect or a different avenue to present the note. If he says yes, well, what kinds of stories? Couldn't the defense counsel have asked those questions?
I mean, he could have, but he didn't. So we're talking about the evidence that was excluded and why it should have been admitted. So if we had the note and her explanation on voir dire, it's that I make up stories. Sometimes I make up stories based on the people in my life. So he could have argued that part to the jury. And then the fact that it's fictional doesn't matter. This court, or not, excuse me, not this court, but the Court of Appeals has held that song lyrics, so essentially, art, whatever, works of fiction, can be used for non-hearsay purposes. So the fact that it's fictional doesn't matter. It still goes to her believability as a witness. And then just going back to the Rule 412 really quickly, the Court of Appeals made that offhand remark about it was being probative to another perpetrator, but the analysis wasn't based on that. That remark was like in the factual background, so that's dicta. But if you really look at the Court of Appeals opinion, it really focused on the whole credibility issue. And I'm gonna jump back.
Let me ask, because to make sure I understand. So your argument is to get at the Chief Justice question. So what at closing argument was your position? Is the argument is to tell the jury, remember that note, and there was never a time when she snuck out and met her boyfriend Larry. But this is a person down with all these details. And so what happened here in this case, she did it again. She snuck out and got caught and was in a lot of trouble and made up another elaborate lie, this time saying that my client had done all sorts of things in order to get her out of trouble for sneaking out. That's what you're saying, that it would have provided some alternative reason to say, oh, she made the whole
understandable that she might be untruthful to begin with. But the note would be some evidence potentially of a lack of truthfulness apart from that scenario. And so the jury might be inclined to look at that and say, yeah, that does call her credibility into question in a way that the perhaps understandable lies to the officer would not. Is that?
I think that could be a part of it, but again, her lies to the police, whether it's because she was like scared of authority or not, her lies were like about herself. Like I said, her age, she's lying about her age, why she left, and the note just adds a different layer. It's like, okay, she's not just lying about herself, she's lying about other people and making up, entirely different stories based on the people in her life. So I think that goes to that. And then of course the similarities and contradictions in the note kind of like tie it together too for why it's important to contest her credibility. So she's saying on direct examination, she told the neighbors that she went to, she was 16, going to see a boyfriend, and then she's admitting on direct examination that she lied about her age and that she didn't actually have a boyfriend. And then we have her admitting on cross-examination that she was speaking to a man named Larry. And then this note kind of ties all of that together regarding her credibility, because on voir dire we see her saying, we see the note refers to the man named Larry as her boyfriend, and she's explaining on voir dire that she thought he was her boyfriend, but he actually wasn't. She never met him, and we get back to the story thing. So it's all connected as far as we can see. She does make up stories based on the people in her life. So again, that still goes to the credibility aspect. And then I'm going to jump back to prejudice. So let's see if you have any more questions. But as I was just emphasizing earlier, the line of cross-examination and defense exhibit 1 that were excluded were distinct from the other credibility evidence in the record. And then in this case, like I said, it's really a credibility contest, right? We have physical evidence that she was sexually abused, right? But that physical evidence didn't necessarily implicate Mr. Leo. So we don't have any physical evidence that actually identifies Mr. Leo as the perpetrator. Of course, he denied the allegations against him. No other witnesses to say that Mr. Leo was acting untoward HL. So the only direct evidence we have is HL's testimony.
So let me ask you this. What precisely did the defendant argue as the reasons to admit the note?
So one of his first arguments was that it was an alternative explanation for why she ran away. And I think
so let's let's talk about that just a minute. That couldn't be an alternative explanation for why she ran away, could it? Because she had already run away. How did she get it back into the house?
I mean, that doesn't, if the note's still in the house, that just means she wrote it before she ran away. So she was just planning to run away. But as far as the relevancy, so that was one reason he said alternative explanation for why she ran away. And then, of course, like I said, 156, he talks about its relevancy. It goes to her believability as a witness, and that's what my argument focused on, because like I said, and like he argued, at one point she's testifying about having a boyfriend. Then this note refers to a man named Larry that she's calling her boyfriend. She says she was going to meet a boyfriend in Hickory, so it's kind of like the inconsistencies and the similarities in what she's saying isn't true, and then like it's actually happening in her real life. And of course, the other thing that he argued was impeachment. She said she was married. Like I said, one argument about her believability. But I hit from the cumulative. So I'm just gonna go ahead and wrap up and say that the jury was able to assess this. That's no possibility.
As an alternative perpetrator to explain the physical findings, because the credibility issue was already before the jury. She was a liar. She admitted she was a liar at she ran away.
Would those be reasonable inferences from this note?
Based on, well, no, Your Honor. Based on how it was presented and the content of it, no, Your Honor. To show that alternative explanation, no. That would be our contention. And the basis in which he was seeking to use it without establishing all of those things I stated earlier, it would not accomplish that goal without more.
With USPS Ground Advantage, it's like you're with us every step of the way. Right on time. Stay in the know from your dock to their door.
I was involved in a motor vehicle accident. I think Morgan & Morgan represented me the best that they could and got me the best settlement that they could.
Morgan & Morgan lived up to what they say they're going to do. They got more than I expected.
They made sure that I got everything that I possibly could and then some. I was amazed.
Morgan & Morgan went out of their way. That's all I can say. They went out of their way and got me what I needed.
It didn't matter that it was just a small injury. They got more money than I would have ever expected.
And again, the defendant does argue, defendant's counsel does argue today that they never argued at trial that the evidence could be used to show an alternative perpetrator. And as I stated, and I think I've belabored that point, of course not. They didn't because of Rule 412. That would have opened up a whole nother, I guess, argument or from the state, because the state had filed that motion in limine. The defendant would have been required to, and was required to file application to get that evidence there. So this was the defendant's attempt to circumvent 412 to get evidence before the jury so they can infer, based on that note, that she had a boyfriend named Larry whom she snuck out to be with and can infer a sexual relationship as to explain those physical findings.
But on page 158 of the transcript, defense counsel argues that the note is also relevant for impeachment purposes because she testified she had not snuck out before, and that entering the note into evidence would allow defense counsel to call that into question. So that's also a basis that the defense counsel argued.
Yes, Your Honor. Even if the note had been admitted, it would have established what the jury already knew, that she lied and that she reported at some prior time a fantasy or a story about sneaking out the window and leaving the house with Larry. The physical transection injury to HL's hymen consistent with sexual abuse and blunt force trauma would have still been before the jury. The physical evidence corroborated her testimony about sexual abuse by showing physical damage to her internal vaginal area resulting from the defendant's sexual abuse. The trial court did not err or commit prejudicial error. Considering all the evidence, including the physical findings that the nurse practitioner testified to, that's indicative of a healed hymenal transection injury consistent with blunt force trauma, there is not a reasonable possibility that the jury would have reached a different verdict. If there are no further questions, the state will rest on its brief.
Thank you, counsel.
Do you know what's really fun? Making a website on Wix.
Hey, we're How Ridiculous, 3 childhood friends and digital content creators that do epic stuff from Perth, Australia.
We've got about 50 million followers. We're in the billions of views. And we're a small town.
ventilating and air conditioning men like the defendants who were working on this machine, who were responsible for this machine, to understand this. Why? Because system pressure within the machine from high pressure refrigerant gas that the defendants knew was there. Actually, when they shut down and secured the machine, they didn't take care of the system pressure. They capped it, and then the cap that they installed blew off, hit Joe Long in the head, and he died 5 days later. So the very hazard that the manual leads off with is what was the cause of Mr. Long's death, system pressure. Now, these men had never drained or secured this machine. This was the first time they had done it. They were responsible. They were trained. They were responsible to take care of this machine. They had this manual in their office, but they never looked at it. They had never done this before. They didn't know the procedures. This is a huge machine. It is mounted on a trailer that can be pulled by a tractor trailer. It's 48, 49 feet long. It's a tremendous machine. Carrier, who manufactures the machine, has this manual that's very detailed, and the record shows that there's over 130 pages in this manual. But the very first thing warns people of the danger, the hazard of system pressure. This would not have happened if one of either of two things had been done. Number one, when they shut down the machine on December 21st, 2016, if the defendants had put antifreeze in the water system of the machine, like the manual called for, and like stickers that were on the machine specified was necessary. If they had used antifreeze, this wouldn't have happened. That's agreed by all the parties. Secondly, it wouldn't have happened if they had removed the high-pressure refrigerant gas that was in the machine that they knew about. There's two pressure vessels, and we'll talk about those in a minute, but there was high-pressure refrigerant inside barrels in the water system that these barrels were designed to withstand 220 pounds of pressure per square inch. That's what the pressure from this refrigerant that they knew was there. And if they had removed the refrigerant when they shut the machine down and secured it, this wouldn't have happened. But they did neither.
Can I ask you a question about,
yes.
I think what your friends are going to argue is the third way that this tragedy could have been avoided, and that is if Mr. Long had followed his training that he had received and stood to the side of the pipe, of any pipe before ever removing a cap. Do you agree that there's undisputed evidence that the decedent received that training, that was part of a duty of ordinary care that he would have known he had there?
I would suggest to you that he did follow this training. There is no evidence in the record exactly where he was standing. It's been argued that he was standing in front, but there is evidence. But more importantly, if you look at record page 834, 834, Mr. Quate, who was testifying about Mr. Long's training, said he would have, it has been argued that he violated his training by the defendants, but they must have missed page 834 because as he was allowed under Rule 30E of the Rules of Civil Procedure, Mr. Quate went back through and read his deposition and clarified and said, if the machine, assuming the chiller was energized, if the chiller had been disconnected from electricity and water for weeks, the defendants had disconnected the water, some electricians had, and it was sitting idle for weeks. And so he did not violate his training. Furthermore, Mr. Quate explained that he would have done exactly the same thing under the same circumstances. So the question is, would a pipe fitter, Mr. Long was a pipe fitter, not an HVAC person, would a pipe fitter under the same or similar circumstances have acted reasonably by doing what he did? Mr. Quate testified he would have done the same thing, as did two other pipe fitters who were deposed.
And on this very point of what evidence there is in the record about where he was standing at the time, Wouldn't the document, these are the photographs now, document exhibit 19 and document exhibit 24, which show, 19 shows blood on the concrete, and 24 shows the gravel area where his partner he was standing. Isn't it a reasonable inference at summary judgment, as we do take the evidence in the light most favorable to the non-moving party, that those two photographs indicate he actually was standing to the side of the pipe?
I wasn't going to get that deep into the weeds, Justice Earls, but yes. But, you know, it can be argued, but there is direct testimony from Mr. Weston, who was there beside him, that they were standing shoulder to shoulder. And if you can look at the shows the inlet and outlet pipes at the end of the machine. If they were standing shoulder to shoulder, there's an 8-inch inlet pipe and an 8-inch outlet pipe. Warm water goes in the inlet, comes out cool on the other. They were standing shoulder to shoulder, and Mr. Weston said, first, Mr. Long had used a crescent wrench to loosen the nut on the bolt, and at that point they smelled no freon, and they didn't hear any hiss, and then they proceeded. Mr. Weston was holding a socket, and Mr. Long was in the process of putting a ratchet wrench on, or a socket wrench, at the time when it exploded. Mr. Weston also testified that the cap did not come straight out. Mr. Weston testified that the cap came off at an angle and spun around. And so we submit that that is a question which needs to be decided by the jury. I've been doing this for 44 and a half years, and it's been my privilege. I represented insurance companies for 11 years. It's been my privilege. I've had the privilege to be. It's not clear about exactly what Mr. Long did, but there is testimony that from reasonable pipe fitters that he did exactly what they would have done and that he acted appropriately. Now, it's also interesting to note, while we're talking about contributory negligence, that on page 26 of the defendant's brief, they admitted, and I quote, "It was unforeseeable to career pipe fitters," close quote, "that this could have happened." Now, foreseeability is an essential element of contributory negligence, and the defendants have conceded that to pipe fitters, this incident would not have been foreseeable. That being the case, we believe on the issue of contributory negligence, it's a jury question. We didn't move for summary judgment. We think this is a case that a jury should decide. We want, on behalf of the Long family, for them to have their constitutional right to a jury trial to let 12 people servicing this equipment can be hazardous due to system pressure. There is plenty of evidence. We've learned, one of the cool things about this, got a word to use up here, one of the cool things about this job, we learn about, not a lot of things, we learn about HVAC machines, how this killer works. And we learned from defendants who are HVAC trained. We learned that they knew that there was compressor refrigerant in these two barrels on the machine. Two barrels. I would commend you to plaintiff's documentary 98 and 100. They show one end of one of those barrels. And the opening there is where the water comes in or comes out of that barrel. That's the outlet, basically. But the defendants knew that these barrels were filled with the high-pressure refrigerant inside a chamber that was designed to withstand the high pressure. But they also knew that inside those barrels were coated with copper. Water flowed into the barrels, go through these copper tubes, the refrigerant that was there all the time surrounding the tube, cool the water as it went through. Then they would go into an 8-inch pipe, go into the next barrel. Again, surrounded by refrigerant. So they knew. In fact, when they did the job, they did what they characterized as a nitrogen purge in the barrel. Now, we don't know where they came up with the idea of the nitrogen purge, because the defendants admitted that there was nothing in the manual that they had ever looked at about that. But they ran nitrogen gas through there because, and they testified, and it's put it in our brief, they wanted to get all of the water out of these tubes inside the chiller barrel, because the day that they drained it, December 21st, 2016. Now, there was an argument by the defendants. Well, this wasn't a winter shutdown, but each of the defendants, as they know, General Thomas testified, December 21st is the first day of winter, and they knew that the machine was going to be shut down according to documents that are in the record for 60 days. So they were shutting the machine down in wintertime. And they testified specifically that they intended to get the water out of the tubes, because if the water remained in the tubes and it froze, it would break the copper tubes that were surrounded by refrigerant, and refrigerant could get into the water system. It's already in the water side of the machine, but it would get into these tubes. Mr. Fowler, one of the defendants, he took HVAC training beginning in 1990, and he worked continuously only in HVAC for 26, 27 years up until when this happened. And he said, and it's quoted in the brief, I think it's page, it may be in the record, I don't want to get this wrong, but it may be page 444, 445, somewhere in there. Quoted. He said, did you want to get the water out? Yes. Why did you want to get the water out? So that the tubes wouldn't, the water wouldn't freeze at the tubes. Would you have done this? Did it matter because of what time of year it was? Yes, it did. Would you have done it in July? No, we wouldn't have done it in July. Why not? Because it's not going to freeze in July. Then I asked him this question. So he said, no, we knew it was open. It's also interesting, I was looking through in preparation for being here today, I was looking through and saw in the affidavits of Mr. Fowler and Mr. Matthews, two of the defendants, that they said when they came to cap the machine, that they smelled, to smell if they could smell any Freon. It's paragraph 15 in Mr. Fowler's affidavit, is paragraph 12 in Mr. Matthews, pages 1734 and 1738 in the record, I believe. And that shows that when they came to cap the machine, they knew that the Freon in the barrels could get out through the water system. We contend that's a reasonable inference, but they went ahead and capped it anyway, and they left the refrigerant. What? If they had taken it out, we wouldn't be here. There would have been a trial. Plaintiff might have won, plaintiff might have lost, but there would have been a trial. We're so glad to be here because this gives us an opportunity to emphasize what facts are in the record that are important. The Court of Appeals didn't have a little argument, and as a result, there were some mistakes of fact in the Court of Appeals decision. Now, those are innocent. Nobody did these on purpose, but had we had the opportunity to be there, we would have been able to point out and answer questions. I'll give you a couple of examples. This hasn't made it to the North Carolina report yet, so this is 906 Southeast 2nd. Page 48 of the opinion from the Court of Appeals, it says, this was caused because refrigerant was not added. Well, refrigerant was the 220 pounds per square inch gas that was in the barrels that was there the whole time. It goes on to say, I believe it's at page 47, that no one could have foreseen that antifreeze would be spilled into the pipes. Well, the point is, they didn't put antifreeze in there. If they had put antifreeze in, it wouldn't have happened. There's also a reference to this occurred because of a chemical reaction that was unexpected. Well, a chemical reaction, this is getting back to my college chemistry when I thought I might be a doctor or something like that. A chemical reaction requires a molecular change. When water freezes into ice, that's not a chemical reaction. But regardless, the defendants knew that the water needed to get out of these tubes because if it didn't, it would freeze and become ice, it would expand, and it would break the tubes. They justified to that.
I understood the reasoning of the Court of Appeals to be, I'm sort of simplifying it here, but that it was the particular injury that resulted that was unforeseeable, that you sort of think of it as the idea that an engineer or maybe just a chemist and things would understand how this machine, or these series of events could lead to a cap exploding off in that manner. But for someone who's just a technician that doesn't have that training, the damage to the machine is foreseeable, but not the sort of sequence of events. This is kind of the Paul's graph that, Cardozo's opinion we all studied in law school situation of the explosive knocking the scale down at the train station sort of thing. And that's what I understood there.
Well, respectfully, plaintiff's document under Exhibit 51 warns of safety considerations due to system pressure. The defendants did appreciate that there was high-pressure refrigerant, that it was in the same vessel as these tubes. They understood if the tubes broke, that the refrigerant would get in there. Paul's graph, as I remember, boy, it's been a long time, but Paul's graph was two reporters are helping somebody get on the train, and somebody drops a suitcase, and it happens to have fireworks in it, and it goes off, and it knocks down a scale on another platform, and the scale falls over and hits somebody. That certainly, I get that. But here, where you have men who understand how this machine works, who are responsible for these 7 buildings, they understood. They, in fact, said, when Mr. Fowler testified, as soon as I heard what happened, I figured it out. I knew what had happened. If he could understand it afterwards, he certainly could have understood. If they had read this, if they had followed this manual and the warning stickers that were on the machine, they said we didn't see it. Mr. Matthews testified, it's quoted, I can't remember the page number, but Mr. Matthews said, if I'd have seen that sticker, I would have gone to talk to my superiors about adding antifreeze. Granted, it does not say if people are shutting down the machine in winter and they fail to read the manual and they leave the refrigerant in there and they leave water so that it can freeze and damage the machine and they cap the machine that a cap might blow out and hit somebody a month later. It doesn't say that. But it's my understanding from the decisions that it's not necessary to foresee the precise injury. What we know is, had this machine been taken care of, this machine is a straight line between the defendant's negligence and the injury. And that's all I know about Paul's graph. Dean Byrd might remember more of it. Rest in peace. But anyway, that is the Paul's graph piece of it, as I understand it. But this is not an attenuated situation like that was. I think that here's the all understand about this machine. Goes through, but defendant's brief uses the term any part of pressurization of the tube. Any part of pressurization. The tube was pressurized. restriction on the water side. So it's not like somebody.
from Carrier that whenever NC State had an issue with this unit, they called Carrier, and Carrier would send certified technicians to impart our clients with this expertise of a certified HVAC technician from Carrier. It's just not proper. It's not in the record. Our clients, again, were mostly maintenance people. I think Mr. Kinsler said he primarily worked on electrical issues. He worked on some HVAC machines, but mostly on the water side. Okay.
But doesn't that just go to? And I'm sorry. Doesn't that just go to? You know, if they they knew they had the manual. There's testimony that they knew the manual was there, but they didn't look at it. Doesn't that go to whether or not they should have attempted to do what they were asked to do if they didn't have the requisite training to actually do it?
Again, I'd argue that does not. Okay, and the reason being, there was nothing in the manual that said this argument today that applicants not to have looked at the manual, not to have put antifreeze into the chiller system. And we'll see what the argument was. The question is that applicant did it foreseeably lead to the kind of conditions or events that led to the death? We argue that it did not. I lost my train of thought, Your Honor, but again, but there was nothing in the manual.
I think with Justice Earls, the question I have this, I'm trying to wrap my mind around the same thing, which is I'm trying to figure out what degree of knowledge do we have to assign here for purposes of assessing foreseeability. And the point would be, well, if you're, to my point about, well, an engineer would know never to do this. The argument would be, well, if even it's just someone that has a lot of training in HVAC maintenance, if someone like that would know, and the argument is, well, you should have had that requisite training in order to be even working on the machine. And then we therefore say, so it wasn't foreseeable because you didn't have the training, but the reason it's negligence is you should have had that training to work on it. It seems to me like there's something wrong with then saying, well, we're going to say it's not foreseeable. It would have been foreseeable to someone who had the training and was potentially, I'm just saying, and that, isn't it then relevant that you're saying your clients maybe should have worked on the machine without that training?
Right, Your Honor. And so, again, they weren't being told to work on the machine. If the court will recall, the order needed to construct some natural gas lines underneath the loading dock. And this trailer, big tractor trailer, over by about 10 feet. They weren't working on it. They were just out. Okay. So they went to drain it, and they thought they drained it completely. And the court will also recall the record, Mr. Quate said about 6 days after these gentlemen drained it, they actually moved the trailer up and down the ramp. They moved forward, moved it over about 8 feet, and they backed up. At the time it was on the incline, the pipes were open, and no water. Everybody thought it was out. Okay? The court will see also in this record, we do have testimony from people who were much more accustomed to working on chiller units than any of our defendants, any of our clients. He was a certified pipe fitter. He'd been certified to work on chiller units. He'd been doing this for over 30 years, Mr. Quake did. Nate Weston, who was one of Mr. Long's co-workers who was standing right there with him, had extensive experience working with chiller units. Both of those gentlemen testified that even with their knowledge of these units, and everybody knows that refrigerant, for the sake of this argument, we'll concede that anyone who works around HVAC units, generally speaking, knows they're pressurized systems. And the warning that he keeps talking about on the manual, that just general warning on the front of it, says, hey, if you're going to work on this system, it's going through the testimony from their experts as well, there is no warning anywhere that says your failure to drain this thing could potentially cause pressurization and could hurt somebody.
So I guess I know I keep coming back to this.
That's okay.
This is what I'm hung up on.
Yes, sir.
So it certainly seems to be the case that it's absolutely foreseeable that there's going to be property damage, injury to the machine, because ordinary people understand. We all know that if there's water in a pipe, the pipe freezes. What's one of the things that could happen? The pipe will burst. But I guess what I'm trying to figure out is, can you then make the next step, which is, if you are on notice that there are pressurized components within the machine, you can understand that somehow the freezing of the water within the pipes can lead to some kind of damage that will then cause pressurized portions of the machine to leak into the pipes, pressurizing the pipes so that if someone tries to take a cap off the pipe, there'll be bodily injury. And that, it seems to be the heart of this case, is figuring out, is that something a reasonable person can foresee, or do you need some sort of training beyond what the defendants have here to see that?
Your Honor, you said it's absolutely foreseeable that there could be damage to the machine, and I'd argue it's not absolutely foreseeable, but arguably, if someone had sued these gentlemen for damage to the machine because those chiller pipes had expanded and been damaged. If someone's carrying a bag and they try to jump on a train, that bag could fall, don't you, sir? Sure. And you know that if that bag has explosives in it and that bag falls on the train tracks and gets run over, it could explode. You know that, don't you, sir? And I'm sure the railman would have said, sure, okay. And you know that if that explosion had taken place on the tracks,
page 118 of his transcript, he acknowledged that there was a ball cock present and that Mr. Long should have used it to determine if there was pressure. So 2 times, Justice Earls, he says the pressure relief valve is not present, but then he does acknowledge the presence of a ball cock that could be used to relieve pressure, so there's no inference there. The last piece is the positioning of Mr. Long. Up until 45 minutes ago, there has never been a contention that Mr. Long was not standing in front of the pipe. The training was clear that Mr. Long should not stand in front of a pipe.
Thank you so much, counsel. Rebuttal.
Good afternoon. My name is John Paul Godwin, here on behalf of the appellant in rebuttal. While it's fresh on my mind, I think it is important, as was mentioned, I believe Justice Earls, that Rusty Quake was shown a picture of the machine, and he testified, and this is in the record on page 699, that he did not see a pressure valve. Nate Weston testified, and this is on page 922 and 923 of the record, that there was not a mechanical hand-driven pressure release valve. So at best, we have conflicting testimony about the existence of a pressure release valve. I think it's important when we're talking about what these men did, it is important, especially with contributory negligence, that what would a reasonable, prudent pipe fitter have done in this situation? And we know what a reasonable, prudent pipe fitter would have done, because Rusty Quake testified under oath that he would have done the same thing. With regard to the positions of Mr. Long, there is no evidence in the record that points to where exactly Mr. Joe Long was standing before he was fatally struck. The only reference is on page 705, I believe, of Rusty Quake's deposition, where he said he didn't know where Joe was standing. Joe Long was killed because of system pressure. System pressure was warned on the first page, first sentence of the first paragraph of this manual as being hazardous. Now, both sides this afternoon, have spent most of the time not really arguing case law. We argue Hallscraft, which took us back to law school, but we're arguing facts. The mere existence of these facts respectfully demonstrate that an issue exists for trial. He was killed by system pressure. It was specifically warned of as being hazardous in the first sentence, as I said, under the heading safety considerations. System pressure in this 48-foot long chiller is hazardous to human life. There was system pressure in it because there was high pressure refrigerant gas in the barrels. Experienced HVAC workers, and these were not just maintenance guys. These were HVAC trained technicians. The record reflects in Mr. Fowler's deposition testimony that he had over 25 years in HVAC experience. He testified in his deposition.
person that's your agent, your P&L, you're going to make money off of it, comes to you and says, here's a blank piece of paper, sign on the dotted line. That if it's at least that, whether or not it's reasonable for you to say, I'm paying this person, I'm going to sign it, I'm going to sign it. Why should a jury decide that?
One, that person, it said, I like this car, it's cool. If you flip around, why does it maybe the agent did wrong? Maybe the agent did something wrong. Marked the wrong box, knew it should have been the mark. That's one argument. And if that is successful, then I love it. And from that, we can see the question. And then we look at the actual result. And if you flip around and if the agent had signed and said, this application is correct, here's the result, I don't think anyone would have a problem saying, yeah, the agent, that was potentially negligent. But when the applicant does it, I don't think it suddenly transforms into some different thing than just because there's a professional on that side. The applicant is doing more about the student, and they're verifying this. What is alleged, but that there is he implies that in his allegations he decided not to do anything past it to do that even if that was so he doesn't get to say I'm going to be willfully blind and therefore I'm concerned with the legal because I don't want to see this on pages.
so, first, sort of the low-hanging fruit here is that we plead in the complaint, and this is on record 67 years, that Mr. Jones signed a blank application of complaint and he signed the statement. Hatcher disagrees with that. Was it blank? Will the rest of the application that even existed?
Help me with that because
like the contract language. Why is that not higher degree of limits?
Well, if it's a commercial transaction at arm's length, maybe that's the argument. Here, my clients entirely rely on this fiduciary relationship because it tells them this is what the customer. Conscious and intentional disregard
even if we accept it's true, they've not arrested the application, given prove that Jones had essentially the duty to go out and discover and seek out and find is there arrested the application. Read. So think about this. What Patrick was saying is it's a matter of law, the motion to dismiss. My client had to go out on his own, search for errors and misrepresentations that he was given, any indication that he needed to do that might exist. Nothing in the complaint that says Patrick somehow, he has to, as a matter of law, disregard what his agent is telling him, which is, don't worry about looking at what's customers on the page. Just disregard that as a matter of law. And go and look behind or look under all the rocks in search of what we want to definitely know. He's got this heightened duty to go out and seek out This isn't just someone who's come off the street corner and said, here's a blank piece of paper, sign it, now there's the comments. This isn't a Nigerian offense type of situation. This is something that's not just in this context, but it has to be taken into account, certainly not for ourselves. So this proposition that my client has a duty to seek out and discover actually not provided single case, a single citation establishing that duty. Cites, in fact, Marbury, we cite Harris versus Union versus this is an case, talks about the duty to read, and it cites the Williams case, which is another map. In that case, talks about the parent has to take so the whole in their brief is sort of ascertained, as they suggest. Ascertain that it's some duty beyond the duty to read article, duty to go out and see what it's good. If you read the Harris case, it's clear from that case and the context of that case that read and ascertain is treated as honest.
insurance, whether they should or shouldn't rescind the policy, not coverage, that's the insurance company. The question is, now that they made that stand, and made that decision, who's responsible? And we've got a single case out there, that says so far as to basically suggest, as I mentioned earlier, that in every single case, the insurer has to trust, has to distrust the agent's or do its own review before that policy that says, regardless of whether it's an insurance agency situation or someone's consulting with an attorney, a doctor, or anything that's said, statements given or commitments made, advice given, and trusted with that by the professional decision on a given job decision that people are so let's speak a little bit more on this issue of the other thing in terms of this duty to exposure. It actually does cite a brief argument here is that that case establishes that situation like this, where insured signs and after that, question is not actually insured, the applicant adopts the that's not what that case says. In fact, that case deals with situations where the agent and the applicant sat down together. Agent is asking applicant questions. Applicant's really giving them answers. So it's not what that case says at all. So this issue didn't want to learn about, okay, even if we assume that there could be some contributing negligence was a client put off his guard, the answer to that is yes, because the worst circumstance could be in the homes case, so you're driving by the current road and constructed here, because in that case, there was no specific insurance. And the insurer says, vacancy problem, I've already got it once, that's the extent of the conversation. The agent is doing the case, doesn't get back and says that the agent turned around and said, let me assure you that I'm going to take your position. Take this following steps. In fact, even just that statement between the insurer and the insurance is a sophisticated insurer. And the agent in that case was good enough to put the insurer off his guard. Just by making that statement and the agent ostensibly doing something to act on it. Good enough to put the insurer off his guard, and that was summary judgment. The pilot case, cited over it's a slightly different scenario. In that case, the agent's application answers done without the applicant's knowledge, binding on the insurer and the insurance company, absent some sort of law or collusion between the applicant and the agent. And so, in that case, the insurer, the applicant, wasn't responsible for the agent's answers. The insurer didn't know it. They had knowledge of it. And so this would help the insurance company to not cover on a single basis. It's hard to square that with interest produced here. Somehow my client should have done more with knowledge of answers to the application. Did not know about it. Agents did not know. A lot of these cases to that point, we talked about, and it's still on the duty to leave, we talked about duty to leave insurance companies. And here, even if Mr. Jones sat down and read the policy, he couldn't have discovered So, there's nothing in the complaint, and this is really hard. 12B6, whereby there's nothing in the complaint that suggests that Jones had any reason to distrust the step 2 actual public no loss. Contributory negligence standard is not so clear on the face of the law. No other conclusion is reasonable at all. Contrary, Jones was entirely reasonable in doing that. I didn't hear an argument about correct, and to that point, your non-J does have, here's specific requirements when you leave the familiarity and that malpractice. That doesn't exist in the data set. The other than that. The other issue with the punitive damages is that actually it's incorrect that my client actually specifically said in his complaint that actually officer, director, or manager participated in the money the aggravated factor. There's nothing in the line that says that. In line B, the rules of civil procedure say that you can be instead of line generally specifically. And they just create really bad policy to every single case plaintiff is suing policy is not done to which is just want to make sure that the defendant is basically aware of what he's going into if this case is actually not going to ever show up in the case. So I didn't know that theory of punitive damages as someone who had authority to act on that pretty well applied when you read all the pages of the complaint. It says actually no one who is actually I will assume the site undue has inspection where it says that. Fortunately, the cover of these things, 1DS15 doesn't say that. It just says you have to prove that it's right. And so, again, this early stage, looks at as part of the Jones could have taken the extra minute to say, where is the application? And if he had done that, and my client said, oh no, I'm not showing it to you, we're in a very different case. There was arguments about the Holmes case. Holmes case is about an insurance policy, not an application. So when you say, I don't want a vacancy exclusion, you can expect that there won't be one in the policy. It's a very different case if in that case, if the applicant said, I don't want a vacancy policy, the agent mistakenly said, it is vacant or it's not vacant, and then the applicant signs and says, this is true. Because the applicant is then taking on, despite what he said earlier, despite whatever he promised earlier, that it is vacant or it is not vacant or however that is expressed, he is then saying this is true because circumstances can change and the insurance agent doesn't have to go behind the applicant and say, now, I got to independently verify that. They have to be able to trust what the applicant is attesting to. As far as the law that allows for this legal principle, it's all those cases that say when you sign something, you are imputed, the knowledge of what's in the document is imputed to you. That is the information that was available to Mr. Jones because he had the ability to read the application, if he had asked about it, if he had wanted to see it, and there are no allegations he was prevented from seeing it. There is an allegation it wasn't provided to him, but not that he was prevented from seeing it.
Can you address the argument that the plaintiff has alleged gross negligence or something higher than that defeats contrib?
Yes, I disagree that it was pled. There is no cause of action entitled gross negligence. He accurately read his paragraph from the negligence section. The Court of Appeals did not address any arguments as to gross negligence. The trial court didn't address gross negligence. The trial court found on behalf of contributory negligence and therefore would have, because he's correct on the law, they would have had to address gross negligence if they were basing their decision on contrib. The dissent didn't address it because it concluded that there's contrib and didn't do any further analysis. So this issue wasn't raised.
But if you pled if we agree that he pled sufficiently to allege entitlement to punitive damages, doesn't that mean he pled at least gross negligence, if not intentional misconduct?
I think even with notice pleading, there has to be some sufficient notice. And when you have a section for punitive damages and then try and bootstrap that into an earlier negligence section and say, well, I really meant that was gross negligence, even though I used the terms negligence the entire time, I think that puts defendants off. But even if we get there, then you have to examine the facts of the case. And the facts of the case are allegedly that my client presented a signature page and filled out an application, arguably incorrectly, but that's what he did.
But the allegations in the complaint, and they may not be able to prove them, but the allegations are, and particularly with respect to punitive damages, that he intentionally misrepresented facts about this property so that he could get the insurance policy placed, and that seems to me to be sufficient to overcome contributory.
And respectfully, I understand the allegation they uses words like intentionally or knowingly to try and do that, but the facts, other than the magic words used, the facts are that this application was filled out when he knew or should have known that there was a pond on the policy and just checked no. There is no indication that he would have known that that would be determined to be a material misrepresentation, or that would have canceled the policy, or that would have prevented coverage from existing. As you recall, the pleadings are that there was coverage. It was just rescinded for the material misrepresentation.
Thank you, counsel. Your time's expired. Good morning. Before we begin our next case, I want to extend, on behalf of the court, a warm welcome to Judge Lager Collins and her judicial writing class from Campbell Law School. Welcome. Our next case is State versus Norman, and we will hear from the appellant.
Thank you, Chief Justice Newby. My name is Michelle Goldman. May it please the court, I represent Mr. Norman in this appeal. I'd like to reserve 6 minutes for rebuttal, if I may. This is a simple case controlled by one of the most straightforward concepts in Fourth Amendment jurisprudence, the scope of the implied license. According to the habits of our country, it is beyond reasonable dispute that no one is implicitly invited to linger on our driveways and peer into windows of cars parked there. That behavior, when it does occur, often results in a call to police or at least an alert to the neighborhood list served. Officers' implicit right to be on our property without a warrant is defined by the same limits that apply to others who are uninvited. When officers pursue information on our property by engaging in behavior not allowed the general public, they are conducting a Fourth Amendment search. Under clear and unassailable Fourth Amendment precedent, they must have either a warrant or meet one of the carefully guarded exceptions to the warrant requirement. The majority below ignored the dispositive issue and created new exceptions to the warrant requirement that contradict controlling precedent. Judge Wood alone, in her dissent, understood that this case turns on whether Detective Diaz and his fellow officers acted within the scope of the implied license when, after no one answered their knock, they lingered on Mr. Norman's property to investigate the Durango. Because Judge Wood identified the issue and applied relevant and controlling precedent and reached the correct result, this court should simply reverse for the reasons given in Judge Wood's dissent. To demonstrate the correctness of Judge Wood's dissent, I intend to break my argument into 3 sections. First, I plan to address the scope of the implied license and discuss how the officers here exceeded that scope. Second, I will address why no exception to the warrant requirement applies. And finally, I will discuss why the Court of Appeals' reliance on the inevitable discovery doctrine to avoid the exclusionary rule must fail. Turning first to the implied license, it must be understood in the context of the Fourth Amendment's core principles. The home is the first among equals when it comes to the Fourth Amendment's protections from government intrusion. That protection extends with equal force to the curtilage, the area immediately surrounding and associated with the home. The warrant requirement is not a technicality.
The trial court's order doesn't tell us, it didn't seem to me anything to know clearly if the vehicle was in the curtilage. But there is a picture in the record which we know the trial court also was aware of. That seems to answer the question.
Correct.
Can we just look at the picture and say that is definitely the curtilage? It's right outside the front door is where the car is parked in the driveway, the Durango is.
I believe so. I don't believe there's ever been any dispute that this was in the curtilage. The officers, as the court has seen the picture, it's clear that the Durango was parked at the apex of the circular driveway, which was near the front door. So I don't think that there can be a serious issue about whether or not this search, Detective Diaz's subsequent search, occurred in the curtilage.
Right, so Collins versus Virginia would say that is completely settled. It appeared the Court of Appeals didn't really understand what Collins versus Virginia is saying, but my reading of it is, if that car is in the curtilage, which I think it is, then you cannot search it. You could, if that was the normal path that, as you said, anyone, the trick-or-treater or the neighborhood people could walk to your front door, you can look in the window.
I think certainly if Detective Diaz had seen something as he was walking to or from the front door, this would be a different case.
So the thing that's I found odd about the court's order is that it has language in there that I think is intended to confirm that the walk to the front door complied with the knock and talk doctrine, because it has this language that says that he used, I think it was like by the shortest route from his vehicle, he went to the door, which seems to be clearly for the knock and talk doctrine.
Correct.
But then on the way back, it doesn't say that anymore. Looking at the picture, you could see a shortest route from the door that would walk at least past the license plate, arguably, of the vehicle. But what is your reading of where the officer went and how, and whether or not that was also the shortest route back from the door to the edge of the property?
You know, I would be more generous than that. I don't necessarily think that the officer has to take the shortest route, you know, but I think from this, what the officer did here clearly exceeds the scope, because he testified that when he left the front door, he didn't leave. He didn't walk back to his car by any route that any reasonably respectful citizen would have taken. He deviated from the permitted purpose of the implied license to investigate the Durango. And I just want to be clear, his search is a search of the curtilage. It's not necessarily, at that point anyway, a search of the Durango. And that's why the whole plain view issue arises.
But I guess what I was getting at, and you're right about that, that's fair. You don't, it may not be the shortest route, but it's got to be the route that's the natural one that you take to and from the door. And what's interesting here is there's even a finding, and there's certainly evidence in the record, that the intent of the officer was to investigate the car, not to walk back out of the property.
Correct.
But if in doing that, you're still going on the path that would be permissible as your sort of exit route in a knock and talk, if your intent subjectively is, boy, I really want to get a look through the windows of the car, that's okay. And so what I'm trying to figure out is in the court's findings, because it does seem, I agree with you, that it does seem like what the officer did by saying he went around and then looking at the picture that we can see, you must have walked on the outer edge of that car, almost on the grass, and then come back around, which seems not the normal route of the implied license. So what's your view on that?
And I think it's important to remember the implied license has sort of three limits. One is durational. This is supposed to be quick. You go up, you knock promptly. If you're not invited to linger, you have to leave. So that's the durational limit. There's the locational limit, which is the front path or the path a reasonably respectful citizen would take. And then there's the purpose limit, which is to contact somebody at the front door. And if that doesn't work out, you have to leave. Here, Detective Diaz admitted, and the trial court found, that he exceeded not only the duration because he didn't leave, but also the purpose. He went and did the things he did for the purpose of investigating the Durango, not for the purpose of trying to contact the homeowner. And right there, I mean, that's sort of the exact same problem that we have in Jardines. There, the officers went to the front porch, which is an area that is recognized to be one that is within the limits of the implied license. But what they did while they were there demonstrated that they were acting outside the approved, permitted purpose. And it doesn't have to do with the subjective intent.
This sort of the struggle I have with that is that some of that is the officer's subjective intent. And that what really matters objectively is where you still within the implied license. And that's where I'm sort of struggling, because imagine that instead of it being this vehicle, it was like a really fancy car like a Ferrari. You can imagine a lot of the people with the implied license walking up to the door, knocking, the salesman, and then on the way back down the driveway saying, man, that's a nice car, I'm really checking it out. But it's just right there in the driveway, you have to walk past it, and so there'd be nothing wrong. So how do we get from just, we know this is what the officer intended, to, and also it went beyond that, what anyone would have the implied license to do?
Well, I think if you think about what just generally we allow people to do, nobody would expect somebody to be on their property staring at their car and looking in its windows, peering in its windows. That would be outside anybody's reasonable expectation of what they were permitted implicitly to do.
I struggle a little bit with that, because like if I owned a Ferrari and it was in my driveway, I would want people to stop and kind of, do you see what I'm saying? That really there's a little bit of a question about, is just looking in the window as you're walking by it, and there's no findings about, how long, what was the officer doing, and that's what I'm struggling with a little bit here.
Well, and I think, in terms of this subjective intent, I think what it is we look at the behavior rather than the officer's subjective intent. And the behavior has to be to communicate with the homeowner. That is the permitted purpose that has been recognized. Well, where an individual might not mind if people come on and look at their Ferrari, that's not the customs of the country that have been approved of in Jardines versus Florida.
Had the officer parked at the first entrance to the driveway and walked by the car, would he have been permitted to look at his eyes?
I think that if an officer glances over as he's walking and sees something in plain view, that's going to be a different case. In this case, that's not what happened. The officer testified that he stopped. He spent more than a minute investigating the license plate, and then he walked around the car to the driver's side, which is not an area he had passed before, or he would have passed had he come up the other side of the driveway. As the court can see in the picture, the Durango was parked, the driver's side was very close to the edge of that side of the driveway, and any path that would have taken somebody from the street to the door would have passed across the other side of the Durango.
From the second entrance, right?
From either entrance.
If we're talking the first entrance to the driveway, and the officer walks up the driveway, wouldn't he or she have to walk by the Durango?
Either way, you would walk by the Durango, one way by the front and one way by the rear, but neither way by the driver's side door. The driver's side door was right next to the grass, and I'm just holding up the picture but the court can see that the wheels of the Durango were almost abutting the grassy area, and the normal path would have taken somebody either by the rear or the front of the Durango to the front door. And just to briefly respond to Justice Dietz's question to finish it, I think that the court in Jardines actually addressed that very issue, permissible purpose and an officer's subjective intent, because that was made. And at page 10 of the opinion, Justice Scalia says that that subjective intent can't invalidate otherwise lawful behavior, but where behavior reveals a purpose to conduct a search, which is not what anybody thinks they're licensed to do, that's where the problem is. It's not what the officer actually wants. He might go to the front door hoping that when the person opens the door, he'll smell marijuana or get consent to search. All those sort of subjective intent issues are not what invalidate the knock and talk.
I guess the real question for me, that persuades me, and I also think there's a number of other things in the Court of Appeals opinion I can ask your friend from the state about that I can't wrap my head around it in terms of Fourth Amendment doctrine. But I think the real heart of this case for me is that you would see the license plate walking up to knock on the door, and I think it would certainly, the Supreme Court of the United States would say it would be okay on the way by for the officer to jot down, this is the license plate number, this vehicle I can see, make and model, and then discover, okay, wait a minute, we're looking for a vehicle that looks exactly like this. This has fake plates. And my question to you is that probable cause for the warrant? And the reason is, although this was not the theory of the Court of Appeals, we do have that independent doctrine, independent source doctrine case law that says if you had these things in the warrant application that were permissible, but then you also saw something, the cigarettes, the lottery tickets, that you shouldn't see, you do have to suppress that lottery ticket, the cigarettes, but you can use the other information to justify the warrant to search the car, and any incriminating evidence found that the officer didn't see in the impermissible, plain view look comes in. So can you focus on why, if I'm wrong about that, tell me why I'm wrong about that.
Okay, I think that this case cannot be saved by the independent source doctrine, because under the independent source doctrine, the warrant, the ultimate warrant, has to be entirely independent of any unlawful activity. And while maybe the officer could note down a license plate while they're walking by, that's not what got him the warrant or got him the probable cause to get the warrant. It was what he saw in the windows. And that is a far more, and that just cannot be supported by sort of anything he could have done within the scope of the implied license. He walked up to the car and looked in. He was able to see the lottery ticket on the driver's side seat, on the driver's seat, which means he had a vantage point of looking down into the car. That's not the same as, you know, inadvertently seeing something as you walk by. So that's one problem with it. But a bigger problem is Detective Diaz testified that he would not have sought the warrant had he not seen the incriminating evidence inside the Durango. And the independent source rule, as discussed in Murray versus the United States, says that it is not a warrant does not provide an independent source if procuring the warrant was a result of an unlawful search, and that's what happened here. So, and I think too, and then the other step is if you excise and re-examine, do you have enough? And if you excise and re-examine the warrant for the Durango here, you don't have enough. All you have is this passenger the day before, you know, a passenger in a car, that's a loose association with the car, having a winning lottery ticket that was taken in a break-in entry a week before. You know, it's just not enough to tie the passenger to the crime or the passenger to the car to get the warrant. And Detective Diaz's discussion of the car and the fictitious plate was very generic. There was nothing in that tied it to the breaking and entering. So the only way he gets a warrant to look for evidence of the breaking and entering is by putting in that warrant application information that he observed unlawfully while he was conducting a warrantless search on Mr. Norman's property.
Can I ask you more specifically about that? As I understand it, you're arguing that, so I'm looking at page 25 of the record, the actual facts to establish probable cause, and it seems to me that paragraphs 13 and 14 are the two that we would have to excise.
Correct.
And your argument is that when you take those two out, the remainder of the affidavit doesn't justify the search warrant.
Absolutely. Absolutely. Yes. And
does the officer have to put aside the facts that the officer is aware of? For example, you would concede that a Dodge Durango missing a front bumper, black with black wheels, that's a bit of an unusual vehicle.
I think that's correct.
And the officer, at least from afar, thought he was able to read a license plate that came back that it was basically stolen. Can the officer have that in their mind as they're walking up to do the knock and talk?
First of all, I would want to say that there was no indication that the license plate was stolen, only that it did not belong to that car. That it was.
So it's a Maryland license plate in North Carolina. It goes back to a car rental place in Maryland. You don't think that raises a reasonable inference that that license plate has been taken from somewhere?
I would assume that when the officer ran the plate, it would have flagged it as stolen if it had been a stolen plate. But that aside, I don't think that, you know, Mr. Norman is not contesting what the detective did in his approach to the house. I think his initial approach, I understand why he wanted to do it. I understand why he thought the car was suspicious to him and the plate was raised suspicions and why he wanted to talk to somebody. But that didn't work out because nobody answered. And at that point, he had to leave under Florida versus Jardines. There were other things he could have done to continue investigating the case, but what he could not do is remain on the property and conduct a search of the curtilage without a warrant and without exigent circumstances. So the fact that he had ample justification for trying to do the knock and talk doesn't change the fact that he has to remain within the scope of that implied license to gather additional information or find another way to do it.
And maybe just repeating Justice Earle's question here, but in the warrant application, so the trial court did make a finding that confirmed statement in the warrant application that coming up to the driveway of the property, the officer saw the license plate. We know the license plate that was a crime, and there was a license plate on that vehicle that did not match that vehicle.
Correct.
So just based on all the other information we just talked about the unique characteristics of the vehicle, that's the one they're looking for, and then that information, your position is that's not enough for any magistrate to sign off on probable cause. You had to also have the fact that the officer saw the lottery ticket and the cigarette, the things that through the window of the car.
So the warrant is for us to look for evidence of a specific crime, which is the break-in from Mr. Pete's convenience store or Mr. Pete's market.
Right, and they know the car they're looking for from that break-in, right?
No, they don't. They only know the car that was associated with a woman passenger trying to cash a ticket a week later, which I would say is not enough to associate that car with the break-in, both because a passenger's association with a car is loose. It's not enough. What we would have to say is it's reasonable to infer that a passenger who possesses a winning lottery ticket, which is much like cash, a week after it's taken, provides a fair probability that evidence of the break-in will be found in the car. And that's a bridge too far.
I mean, I would frame it as, we know that someone using this vehicle had contraband. We then learn that the vehicle has a fake license plate, which you can certainly imagine that people engaged in criminal activity would do something like that to avoid being identified because they're engaged in some sort of criminal activity, like they have contraband, and that would get you the probable cause to say evidence of that illegal activity is in this vehicle that has a fake license plate, which is the sort of thing that you could reasonably infer would be, okay, it's involved in the crime.
And if you look at what the warrant says about cars bearing fictitious license plates, it's very generic. It is people who commit crimes often use fictitious license plates or whatever. It does not in any way tie that car to the break-in at Mr. Pete's almost a week before in a different town. And the only thing that ties that car to that break-in is this female passenger a week later with something that is essentially cash. In looking through the warrant more carefully, it doesn't even say that she took the unredeemed ticket with her. So we don't even know that would be in it. And it's just too far of a leap to get to probable cause, a fair probability that this car will have evidence of a break-in that happened so long ago.
If we agree with you that it was impermissible for the officer to look through the window of the Durango, doesn't State v. McKinney tell us we ought to remand the case to the trial court to do a probable cause determination absent of tainted evidence?
I think State v. McKinney does say that, and that would be a perfectly acceptable result here. I think looking at the warrant and excising those paragraphs that contain the unlawfully obtained evidence, there's really no way this warrant survives. But should the court disagree with me, then yes, I believe that the appropriate approach would be to reverse the trial court's denial of the motion to suppress and remand for the court to conduct an excise and re-examine test on the warrant. The court does not have any further questions. I'll reserve the rest of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Good morning, and if it pleases the Court. Good morning, Mr. Chief Justice and Associate Justices. My name is Robert Brackett. I represent the state in this matter. And I have to disagree with Ms. Goldman somewhat in that the issue that this case brings to the court is not so much just whether or not a knock and talk was conducted within the implied license that all citizens are given, but whether or not, objectively, the search warrant in this case conferred probable cause to search the Durango for evidence of a crime. Considering that the question that's before this court is related to the objective reasonableness in the search warrant, this court's prior precedent also would direct that we give great deference to the reviewing magistrate in their determination of probable cause, and secondarily, also defer to the trial court and its findings of fact, because ultimately that's what was in front of the Court of Appeals. The Court of Appeals majority opinion does recognize that probable cause existed. It may not hit the language that would be perfect for my position in this case, but it does discuss objective factors that did exist even prior to Detective Diaz stepping on the property at Step Acres Mill Lane. He knew that an incredibly sophisticated breaking and entering occurred in Fletcher on December 12th. He knew that a very recognizable vehicle, missing a front bumper, a Durango with black rims, was used to attempt to pass a lottery ticket that was the substance of the breaking and entering at Mr. Pete's. And that attempt to pass was only 4 days after the breaking and entering, not a full week. Detective Diaz discovered that on February 16th. I'm sorry, on February 17th. The attempt to pass was on February 16th. And that was at 1 p.m. By 4 p.m., he had already received a search warrant to search the Durango. And the most important factor when we're considering whether a search warrant confers probable cause or not is not whether a person is involved in a crime, but whether the proper nexus has been created between evidence and location. And in this instance, in 24 hours, evidence being found in that Durango there's a fair probability that Detective Diaz could have found evidence in that Durango based purely on the information he had before he even approached the residence to knock on the front door. He knew that a very specific stolen item was possessed in that vehicle at 1 p.m. on February 16th. He also knew that that vehicle, that Durango, drove in a very specific direction. And in a very short period of time after Detective Diaz left Edneyville General Store, he found the Durango just off of US 64 on Step Acres Lane. Detective Diaz's testimony was it was a 5 to 10 minute drive. So we have temporal proximity in that the evidence was seen in a very recent time frame in the vehicle, and we have a locational proximity. The house, the residence where the vehicle was very close to the location where the stolen property had been possessed on video that Detective Diaz had seen. And then when he approaches the house as he's driving up the road, he sees that this vehicle has a tag that is, in his words and in the search warrant application, fictitious, but the state would argue that that could also be considered a stolen tag. Either way, in just recognizing that this tag did not belong to the Dodge Durango, rather it belonged to EAN Holdings, should have been on a Dodge Ram truck. Either way, that's a crime. If you look at it purely as a fictitious tag, it's a Class 3 misdemeanor. If you look at it as stolen property, it's a Class 1. So before he even parked at the far end of the driveway, before Detective Diaz called for backup, the Court of Appeals correctly found that he did have probable cause to search that vehicle.
So why not just sit on the house at that point and get a search warrant?
That certainly could have been a cleaner way to do it, but Detective Diaz, in his testimony, said that he wanted to talk to the residents at that particular house just to see if they had any other information as to how they came about getting that particular ticket. That he was attempting to potentially look at gathering more information in his investigation at that moment shouldn't negate the fact that he already had this information in hand before he approached the residents.
So if the Durango had been over in the grass, parked away from the house, and the officer testified exactly what testified here, he really wanted to take a look. That's the reason he's there. So he walks off the porch and then cuts across into the grass and looks around. Would you concede that that violates precedent from the Supreme Court of the United States, that's not part of the knock?
That would certainly consist of traversing curtilage.
So the Court of Appeals does not see this nuance, it seems to me. So at a minimum on that question, we would need to correct that misunderstanding with this opinion about what is the extent of what you can do in a knock and talk. Would you agree with that?
The Court of Appeals opinion in this case does not touch on that at all. As Your Honor,
kind of discard Collins versus Virginia as if it's just irrelevant, that it's a car and you can go and search it, which is certainly not correct.
I'm not sure that I would agree with it entirely. The Collins versus Virginia case seems to have a little bit more of a substance to it when kind of analyzing an officer's actions within the curtilage. In that, first, Collins sort of balances out the protections of the curtilage versus the state of Virginia's argument that the Carroll Doctrine should permit them to search that vehicle. Second, in that case, an officer went on the property specifically to find evidence, which is not what Detective Diaz was doing at that residence. And so when the officer in Collins did actually lift up a tarp, he committed that trespass while trespassing, so to speak. So I see that there's a distinction there between that holding and what has occurred here.
Well, what about, the Court of Appeals also held that it would have been okay under some precedent, court cited the McKinney case that we've already talked about, and then a Court of Appeals decision, to linger on the property while another officer went to get a search warrant. Is that consistent with the Fourth Amendment?
If you classify what was done as lingering, it is not. And I will point
to the Court of Appeals, what it said. That's what it says, and that's a holding. So that would be the law in the state unless we corrected it. So is that the law under the Fourth Amendment?
That officers can linger?
That in a situation like this, the officers, knowing that they've got probable cause to get the warrant because of the license plate, could just linger next to the car in the driveway outside the home without a warrant while another officer drives to go get a warrant.
That fact scenario sounds similar to what this court has held in Grice. Because in the Grice case, officers were on the property conducting a knock and talk, and they saw evidence. And State versus Pyland, another Court of Appeals case, actually describes that action as lingering, which may need to be cleaned up as well.
It's only if you can see something that creates the exigency. So of course, if you see, you happen to see in the window, in the knock and talk, and no one answers the door, there's somebody flushing a bunch of powder down the toilet. That you may be able to go in the house at that point because there's an exigent circumstance. But in a scenario where you would need a warrant in order to search the property, you can't just say, well, I'm going to stay on the property until we show up with a warrant, because trick-or-treaters and everybody else, after they've knocked on your door, they have to leave. It seems to me that that's incompatible with Jardines. To say, well, you can just hang around because we know we're going to come back with a warrant eventually.
So I see that there's a distinction even in talking about what hanging around looks like in this instance. There's what Detective Diaz did, which is, I would say, less an investigation into the Durango and more a confirmation of what he already knew. And then there's what happened after Detective Diaz left. And what happened after Detective Diaz left is not part and parcel parcel of the search warrant that's at issue here. However, an exigency presented itself at that time. The remaining officers in that instance could have done something. They could have been a little bit more, I guess, discreet in their actions, and as if in maybe moving to secure the scene while Detective Diaz is writing the search warrant, moving themselves to the street 15 feet from the Durango, and then that part of the discussion is not being had. With Detective Diaz confirming, and I'll point to the trial court's findings of fact in the record, page 69. Detective Diaz, or the trial court paints Detective Diaz's motions as direct actions. There's a direct from his vehicle to the door. There's a direct from the vehicle to, or from the door to the rear of the vehicle, a direct from the rear of the vehicle to the driver's window, and then back to his vehicle. And lingering such that it was is no different than what occurred in Grice. Because in Grice, officers spent time. They don't testify, or at least the opinion doesn't reveal how much time the officers spent in that case on the phone with their captain, but they were on the phone, and in the Court of Appeals, in Pyland did say, lingered during that time period, but this court found that that action was constitutional. So I believe I would put to this court that there's no great distinction between this case and Grice in that respect. The only small distinction is when the call was placed. Diaz placed it, again, looking in the four corners of the document, Diaz placed that phone call to dispatch before he says he saw the lottery ticket and the pack of cigarettes on the dash of the vehicle. In testimony, he tried to clarify that, and he did say he couldn't recall exactly if he saw it as he walked, the pack of cigarettes on the dash as he walked up to the door or as he was leaving. But in either event, that's not, I wouldn't categorize that as looking into the window, seeing something on the dash, through the largest piece of glass that's on most vehicles, the windshield. It's as if we're asking, or it's as if the defense is asking that officers have blinders on as they walk to a front door and not look in the vehicle.
How do you answer the point that the defendant's counsel is arguing that they had to look down to see the lottery ticket in the seat as opposed to it being up on that dashboard? How do you respond?
I would say that that's nothing that any reasonable person might do in the curtilage of someone's residence if they're walking by a car. And this court in Grice specifically notes that officers can do, a person exposing something in plain view runs that risk of what someone might see in their vehicle.
Do you agree that we can look at the photograph and, yes, and that to get to the driver's side window, he was doing more than just walking past the car?
In the photograph, Your Honor, I'd say he walked from the rear of the vehicle, and the trial court's findings of fact echo this. He walked from the rear towards the front of the vehicle, which would have been by the driver's side, which was in the direction that Detective Diaz's vehicle was located.
Well, the trial court found the fact that Detective Diaz went to the window of the driver's side.
Yes.
Doesn't say he happened to pass by.
And I would say that there's certainly a rational inference that can be drawn that for Detective Diaz, who's parked on the far side of this driveway, to get from the rear of his vehicle, or the rear of the Durango to his vehicle, he would have to walk past the front driver's side of the vehicle. And in this
really
instance,
looks to me like you would have to be standing on the grass in order to look in the actual driver's side.
Certainly,
again, I don't want the trick-or-treaters walking on my grass when they come. I have a pathway that goes to my front door, and I think that's the understanding of the implied license is what reasonable person would think is the way to go to knock on the door.
And while that picture, Defendant's Exhibit 2, is extremely illustrative of where the vehicle was in the driveway, the search warrant itself If I may point the court to page 21 in the record. Now, admittedly, these photographs are not the clearest of quality, but the photograph on the left shows the Durango's positioning relative to the front door in relation to where Detective Diaz actually began his knock and talk. And if, in looking at that photograph, the driver's door is directly within the path he would have had to take to get to the door to even conduct a knock and talk.
I realize that the state's position is that there was probable cause even without what Detective Diaz saw when he looked in the vehicle. But if we do conclude that the look in the vehicle was outside the scope of the knock and talk, I have the same question for you that I had for your opposing counsel. Does McKinney tell us that the proper course is to remand for the trial court to make a determination in the first instance as to whether there was probable cause without that, without the evidence that Detective Diaz saw when he looked in the vehicle?
And Justice Allen, I would echo Ms. Goldman's statement. McKinney does say if the court is going to excise and re-examine, generally the trial court is the best court to make that determination of assessing whether probable cause existed at that time. However,
isn't that a question of law, though?
It can be a question of law, Your Honor, in as much as you have the fully developed record in front of you. We have the search warrant in front of this court such that it can look at that particular documentation and determine, as the Court of Appeals did, that even independent of that, probable cause still did exist. And really what we're looking at and what this court is tasked with is determining whether an error of law existed in that Court of Appeals opinion.
Right. And if the record is in fact fully developed, then the trial court is in no better position than us to make that determination.
Not at this point, no, Your Honor. So the way the search warrant is written, though, McKinney generally says that excising and re-examining would require a trial court to determine whether or not probable cause existed. In this instance, the search warrant, the transcripts provide ample information for this court to determine whether or not probable cause existed outside of anything that this, assuming the court found that looking at a vehicle while approaching the house, while leaving a house is unconstitutional. This court's still in a position to be able to make that decision.
So we've talked a lot about independent source doctrine. What the Court of Appeals relied on was inevitable discovery. And I'm just going to summarize as I understand the Court of Appeals theory of inevitable discovery, is that if you have probable cause such that if you went and got a warrant, you could force your way into someone's home and find a bunch of incriminating evidence. That if instead you walk up to the door and kick it in, and without a warrant search and find that same evidence, you can just introduce it because inevitable discovery says after you got the warrant, you would have found it anyway, which seems to me an absurd take on inevitable discovery. So are you defending that, or do you just not know what that's?
In my brief, I will say that when the state was discussing inevitable discovery, it wasn't pointed towards the entirety of the evidence that was found against the defendant in this case. It was really pointed towards issues that both the dissent and defense raised, in that identity of the defendant may not have been discovered absent an officer looking at the VIN of the vehicle and then the VIN of the vehicle itself appearing on the search warrant. So in regard to that layer of inevitable discovery, the defendant's identity was going to be discovered, and in fact was discovered by an independent source, that being the landlord, who provided the names of both the defendant and Miss Atkinson, who lived at the residence, and provided the phone number to contact them. And
the point I was making is, suppose if the officers here had, in addition to walking around to the driver's side, looking and they're seeing these things, also said, you know what, I remember something about an automobile exception where I don't even need a warrant here, so just went ahead and opened it up and found all the rest of the incriminating evidence. That you could not then argue, well, but look, if we excise the things they saw there, you still would have gotten the warrant, so it all comes in under inevitable discovery. I mean, you can see that that is not what the inevitable discovery doctrine is about.
Certainly, and I understand
that is what the Court of Appeals seemed to think it was.
The Court of Appeals discussion on inevitable discovery doesn't seem to hit the mark as to what the heart of inevitable discovery truly is in that instance. I would also ask the court in this case to consider the fact that officers, when on the property, conducting a knock and talk, there's been no case that breaks it down specifically into 3 separate segments: the approach, the knock, the leaving. The entirety of the process is judged on a objectively reasonable standard, and it's what a reasonable person could do while conducting this procedure. And in Jardine, Justice Scalia discusses the fact that a reasonable person looks like a peddler, a Girl Scout, a trick-or-treater that's walking onto the property. And in that instance, we don't ask officers to act perfectly. They just need to be bounded by what a reasonable person could do.
And I think that's a good point. Some of the discussion seems to focus on, Officer Diaz needed to be 2 feet on the pavement at the entire time he was walking to and from. But Officer Borelli, or Farrell, was on the grass between the street and the Durango. Right? And so it would seem that officer safety, those sorts of considerations would go into location as well.
And not only that, Your Honor, but the trial court's findings of fact also note that looking in the vehicle was done for officer safety. And I would put to the court that it would be unreasonable to ask officers to approach an unknown residence without at least verifying that no one is in a vehicle parked out front that could wish them harm.
Well, I would agree with you if it were Officer Barrow. Right? He's standing out there as Diaz goes to the door. Had Officer Barrow looked in the vehicle, do you think we would have the same discussion about the impropriety of the conduct here?
The discussion would be different in as much as when Burrell was in the vehicle and looking in the vehicle, that was prior to or concomitant with Detective Diaz's knocking and the procedure at which he was at the front door. The discussion is only different in as much as Diaz also looked in the vehicle after he left the front porch.
Does the fact that Detective Diaz didn't look into the vehicle until after he went to the front door, does that undermine the officer safety argument?
If Detective Diaz were the only officer on scene, that would be a much more difficult proposition for the state to report. But Detective Diaz went across the street, waited at Turf Mountain Sod until backup came to the location, and actually approached with a second officer to the porch while leaving Detective Burrell and a third Henderson County Sheriff's deputy to, I guess, more or less look over the Durango to make sure that no one was in there that was intending to do them harm. So if it were a one-officer situation, yes, that would not comport with that officer safety argument. But in this instance, the steps that were taken during the procedure did actually lead to at least the appearance that officer safety was a concern as Diaz was approaching the residence.
You talked about a reasonable person standard. Here, this is not just a simple knock and talk. It's an officer that has specific information, that a license plate is either, it's clearly rolling on a vehicle and perhaps has been stolen, both of which you've indicated are crimes. You also have an officer who is aware of the uniqueness of this vehicle, given the information that he had previously received. What additional things, if any, could an officer do who has that information? with regard to the vehicle.
Make sure I'm understanding. You're asking what else an officer could do in that situation?
If an officer knows that a license plate is stolen, is it reasonable for the officer to go to the VIN and say, well, I wonder whose car this really is? It's clearly the license plate's on the wrong car.
Were the vehicle in a public location, certainly that would be undisputed. That it's on the curtilage of this residence, the stolen or the fictitious tag on the vehicle lends itself to secondary analysis to whether the vehicle itself would be seized lawfully in the curtilage just based on that alone. The officer going up and looking at the VIN would seemingly fall more under the Collins type of analysis. Not that Collins would control as much, but it would look to see if there are more objective factors and what the officer did to actually discover them. That makes sense. And I think that the court, this court in Grice, can sort of, that can be instructive in that situation, and that the quote is that in Grice, no private interest in contraband in plain view of the driveway where any member of the public coming to the door might have seen it. And any member of the public in your scenario, Justice Newby, could have seen and might have seen the VIN. They might not have written it down. It might not have been significant to them, but that's a risk that's a person runs in leaving instrumentalities of a crime in plain view, even while it's on their curtilage. There's ample evidence, as I have noted, and I believe that the Court of Appeals has at least identified that probable cause existed in this case, especially when we provide deference to the magistrate in this case. The law of knock and talk, though the trial court's order does note that the Detective Diaz took the shortest route from his vehicle to the front door, does not require that. It requires a front path that a reasonable person would take to get to and then leave the residence. In this case, with the proximity of the vehicle to the front door, it would have been reasonable for any citizen to walk around the front bumper or the rear of this vehicle when going to the door to engage a resident in conversation. On that, the knock and talk portion of this search warrant, paragraphs, I believe, 13 and 14 of the search warrant, would stand as lawful actions that Detective Diaz took, because it's something that any of us could have done if we had approached that residence. With that, I would ask that the court affirm the trial court's denial of the motion to suppress the search warrant and the fruits of this warrant in this case. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. I think it's important to go back to those core Fourth Amendment principles that a warrantless search of a residence is presumptively unconstitutional. And starting from that place, we look at whether Detective Diaz's actions were justified under the knock and talk doctrine or any exception to the warrant requirement. The fact that Detective Diaz had information that inspired him to investigate, inspired him to go to the front door and knock, is not an exception to the warrant requirement. He needed probable cause and exigent circumstances.